Namaskar, good morning, Suraj Singh, Faridabad, NCR, Bharat, India. About our country and other countries, particularly our country. 26th December 2019 this is. And work, world Georgian year is going to end after 4 days, 5 days. 2020 shall come in, different year. I'll tell, I'll tell about that later on, but this time in continuation to current issues in our country, also in other countries to be discussed, to be deliberated with public and particularly with young generation who is expected certainly to be future of this country and all young generations to be considered futures of respective countries. Nation Bharat is great. We all know. We all know it's very great. And nation Bharat, India is not new nation. It's very ancient nation. As Indira told Nixon, your country is young, your country US is young, but my country, India, Bharat, has been an ancient nation. I just quote this from Indira's speeches in New York, in America, when she landed there. Well, just for that, because our nation is ancient, that is a great issue. Those who are young nations, they talk a lot, but we do not talk a lot, we do a lot. Bharat. Actually, Bharat is not this Bharat. It is very small in this. Once Bharat was name of whole earth because Bharat ruled everywhere, all over the world. It's not simply this, but it lost its areas and now it is this one, whatever is today. We call Bharat, SSSDR Bharat, and British took their way, British India, and before that Hindustan, and whatever it was, Aryavat, or whatever what it was. Leave that aside, but this is history. We have to relate it to ourselves because we are Bharat, SSDR Bharat, we people of this country, having solemnly resolved ourselves to constitute this nation, Bharat India, into sovereign, socialist, secular, democratic republic and ensure and secure to its people justice, liberty, and equality, to create brotherhood and fraternity and honor for every individual, etc., etc. In 1949, and our constitution started fully in absolute terms, effective 1950 onwards, and it's enforced yet. It has not been scrapped. It's a great crown for every individual of this country. It's crown for every new baby, and it's crown for all. Constitution India is a feature in my cap, you can say. I am wearing this cap where Union of India is ruled by Constitution of India, and Constitution of India is ruled by Public of India, Public of Bharat, भारत का संविधान, भारत के पब्लिक, हम भारत के लोग सत्य निष्ठा से फैसला किया करते, ये डिसाइड किया कि हम भारत के लोग इस देश को प्रभुसत्ता संपन्न समाजवाद, पंथ निरपेक्ष या धर्म निरपेक्षता, लोकतंत्र, गणतंत्र के रूप में बनाएंगे और सबको हम गारंटी देते हैं, सिक्योर करते, सुरक्षित करते हैं उनके हक में कि सबको न्याय मिलेगा, सबको बराबरी मिलेगी और सबको अवसर मिलेंगे जैसा भी कोई होगा, जिससे कि सब में भाईचारा बने, देश में एकता रहे, हर व्यक्ति का मान सम्मान रहे। यह है हमारा संविधान की, आप कह सकते हैं संविधान का सर कह सकते हैं इसको आप, या भारत कह सकते हैं, और अंदर तो स्ट्रक्चर है आर्टिकल्स का, अनुच्छेदों का। जो व्यक्ति इनको समझ जाएगा भारत में वो इंटेलिजेंट कहलाएगा, जो नहीं समझेगा उसको मैं क्या कहूँ, आप स्वयं समझ सकते हैं। भारत का संविधान, कॉन्स्टिट्यूशन ऑफ इंडिया इज योर सोल, you must understand it, and if you cannot understand it, you lose something. You lose something really. We did not get this country by walking or by just asking for. It was lost from our forefathers hundreds of years back, thousands of years back, and it was captured back from those people who kidnapped us kidnapped us in law, kidnapped us in free status, and we were slaves for centuries and millenniums. We got it back. We got it back by sacrificing lakhs and lakhs and millions of our people, our blood, our soul. I'm not talking of the religion because they belong to all religions. Therefore, religion has got no place there. It was human struggle, Bharat human struggle to achieve its honor, its blood, its power, its land, its resources, its soul back from those robbers, those masters who tortured us for centuries. And it's not free of cost that we got back. We got back in 1947. Until 1947, we were ruled by Government of India Act 1935, and before that Government of India Act 1919. So 1947, we got freedom from their rule, and we were ruled by 1935 Government Act. That act's the URL I have put here in text video, and I'll talk about that also today, so that at least first we know what Government of India Act was, what it did, and then how it reached government. Independence of India Act 1947, which I discussed yesterday. Half of that Article 14 or Section 14, I have talked and will talk further on that. So it's very serious matter. You cannot leave it just, it is nothing until we know what we are, until I know what I am, what education I have, what experience I have. I cannot define myself, I cannot express myself, my capability either in speech or in writing or in work, whatever it is. I have to express, I have to project myself to some points, to some, you can say, profile. Only then somebody can understand me. And same thing applies to my country. If I understand my country, I can explain, or I can understand what I am. To stay in darkness is very easy. Darkness is very easy. Everybody can stay there. Darkness is also not blank. It's not empty. Darkness also constitutes something, some issue, some power. But light changes everything. So we have to move from darkness to light. Darkness cannot stay forever, but light also cannot stay forever if we do not control that. We are in light now because we got independence. Since 1947, we have been in light. But that light we have to control in some appliance, or this light shall go away. We have to be careful. It's only 72 years since we got independence has been there, but yeah, we are thinking we have traveled a lot. We have not traveled a lot. We are not just come out of exit yet of darkness, and we are still in darkness. That darkness must become understood what that is, and then we can only say, darkness is that we are not understanding. We have not understood yet value of freedom, value of independence, value of authority, and value of resources. And endowed to us by nature, by God, whoever God that is, no question of name. God is God, power is power, soul is soul. We have been endowed so much as a part of this earth. So we should respect that. We can value that only when we preserve it. And if we can preserve the value of power, and we have power in this, we should have people, and our people are there or not there, we have to see. If you bring some robbers to power, we cannot expect our preservation of wealth, and our preservation of wealth is being hacked by certain people. Those who are enemies, internal enemies, external enemies, both enemies can be there. हम लोगों को सोचना चाहिए, हमें आज़ादी कोई खेलते हुए, चलते हुए, फिरते हुए मुफ्त में नहीं मिल गई कि हमने छोले पे उसे खरीदे और खा लिए। स्वतंत्रता प्राप्ति के लिए लाखों लोगों ने कुर्बानियां दी। कितनों ने दी मैं नहीं जानता, बहुत लोगों ने कुर्बानियां दी, और वहां धर्म का प्रश्न नहीं था कि कौन से धर्म के लोग कुर्बानी देंगे, कौन से नहीं देंगे। बिना धर्म की सोच के, बिना जाति की सोच के लोगों ने आगे बढ़े, और ज्यादातर लोग उसमें शामिल हुए। कुछ लोग शामिल नहीं हुए, उनका नाम लेने का फायदा नहीं। ये स्वतंत्रता मुफ्त फ्री में नहीं मिल जाती है, इसके लिए बहुत मेहनत करनी पड़ी और सेक्रीफाइस देने पड़े, जाने लगे, सब कुछ गया, तब जाके स्वतंत्रता प्राप्त। आज हम उसका मूल्यांकन कैसे करें हम नहीं जानते। हम कर भी सकते हैं, हम इतने 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 उसके लिए लायक भी हैं कि हम उस मूल्यांकन को करें। उन सेक्रीफाइसेस को जो हमारे फादर्स के फादर्स दी होगी, उसका मूल्यांकन करना इतना आसान नहीं है। हम बातें कर सकते हैं, बड़ी बड़ी तड़ियां मार सकते हैं, बड़ी बड़ी शोर मचा सकते हैं, गाने गा सकते हैं, स्लोगान गा सकते हैं, नारे लगा सकते हैं, लेकिन सवाल उठता है बलिदान का। बलिदान कौन कर सकता है? वो कहेंगे अब किस लिए बलिदान चाहिए, हम तो स्वतंत्र हो चुके हैं। हाँ, आप स्वतंत्र हो चुके हैं, लेकिन स्वतंत्रता मतलब नहीं जानते आप नहीं जानते स्वतंत्रता किस चिड़िया का नाम है। आपने सांस लिया, अपने सरकार में हो कि अपनी सरकार के अंदर से सोचते हैं आप स्वतंत्र हो गए, आप जो मर्जी करेंगे। वास्तव में क्या आप स्वतंत्र हैं? ये सवाल देखना है। हमें सैकड़ों सालों तक गुलामी की, हजारों सालों तक किस किस की गुलामी की हम नहीं जानते और जानना भी नहीं चाहते। अब सीखना जरूर चाहते हैं। कहते हैं जो पिछली जो हिस्ट्री से, इतिहास से आप अगर प्रश्न नहीं करते या उससे आंसर नहीं मांगते, उत्तर नहीं मांगते, मतलब ये कि आप अगर इतिहास से सीखना चाहते हैं तो सीख सकते हैं, और वो सीखना बहुत आवश्यक होता है। अगर आप इतिहास की गलतियों से नहीं सीखेंगे तो आप फिर अपने माइंड को, अपनी शक्ति को सही तरह से प्रयोग नहीं ला सकते। और उसको कहते हैं कि ये गलतियां करके भी नहीं सीखता, तो उसे आप क्या कहेंगे, आप समझ सकते हैं। उसका टाइटल देने की जरूरत नहीं है। हम लोग ऐसा बनना चाहते हैं या नहीं बनना चाहते हैं, हमको फैसला करना है। हमने कहा हम भारत के लोग हैं, हमारा संविधान में क्या बोलता है हम जानते हैं, हमें स्वयं संविधान बनाया है। हम भारत के लोगों ने सत्यनिष्ठा से इस संविधान का निर्माण किया है। हमने कहा है कि हमारा संविधान प्रभुसत्ता संपन्न से चलेगा, समाजवाद से चलेगा, तंत्रनिरपेक्षता से चलेगा, लोकतंत्र से चलेगा तथा गणतंत्र से चलेगा। पर देखना यह क्या चल रहा है, क्या हम न्याय दे पाए हैं सबको? क्या हम बराबरी दे पाए हैं सबको? स्वतंत्रता दे पाए हैं सबको? क्या हम भाईचारा कायम कर पाए हैं, नहीं कर पाए हैं? देखना होगा। हर व्यक्ति की मान सम्मान दे पाए कि नहीं दे पाए, देखना चाहिए या नहीं देखना चाहिए, ये फैसला करना होगा। कब करेंगे? सन 2500 में करेंगे या सन 2020 में करेंगे या 2019 में करेंगे? कब करेंगे? क्या आज भी हम अपने आप को धर्मों में जाते हुए बांट के रखेंगे? बहुत बड़ा इशू बन जाता है। खेल करते करते 1947 से हम आ गए, और 1935 से 1947 तक हम किसके कानून के नियम में थे? गवर्नमेंट ऑफ इंडिया एक्ट 1935, भारत सरकार का अधिनियम 1935, और उससे पहले भारत सरकार का अधिनियम 1919, जो हमारी ब्रिटिश संसद से पास होकर आई थे। उसके बारे में मैं आज डिस्कस करूंगा। 1935 का अधिनियम क्या है? हालांकि उनका कोई मतलब नहीं है, लेकिन मतलब जानने के लिए वो था क्या, उससे हमें पता लगता है कि आज हम क्या हैं। उसकी कभी कभी कब्र भी खोदनी पड़ती है जानने के लिए कि वो क्या था। उस इतिहास के दस्तावेजों से लाना पड़ता है, और मैं कोशिश करूंगा उसको बताने की। आज एक लंबा चौड़ा दस्तावेज है वो, इट्स अ लॉन्ग डॉक्यूमेंट, मोर देन 900 पेजेस, बट आई विल ट्राई टू titles about that because very important for everybody to understand that. If you cannot understand what it was, you cannot understand what today we are. Why we got independence, what was the reason behind that. हमें जानना चाहिए कारण क्या था, कि इतना क्यों हुआ, और पहली बात हम गुलामी क्यों हुए थे, ये भी बहुत बड़ी बात है। Why we got enslaved with these people, because there's some we are sleeping society. Once again, I told you once, I was there in 1985 in London, just had tour. I was staying in guest house. It was a very old veteran person, 85 years, he is there, 85 years. We were just discussing about our issue, national issues, and so I just you is enslaved us, and he stopped me on that. So don't blame us to enslave you. हम उन्होंने कहा आप क्यों कहते हैं कि हमने आपको गुलाम बनाया? He just told a story. Actually, it was a fact. He said there were 3,000 people in our jails in Berlin. They were criminals. We had no money to spend on them for their food, for their livings. What we did, we awarded them, we sent them to exile. तड़ी पार, कहा हमने तड़ी पार हो जाइए, अब जाइए देश छोड़ के, और हमने उनको देश निकाला दे दिया। We exiled them, and they were so smart, they were criminals so smart, they crossed seas and reached various nations, various areas later which were ruled by British. Those 3,000 prisoners even left Britain. They reached your country, Bharat, India. Only these people reached there. They reached Arab, and they reached your country and the Arab country. Only 3,000 people spread all over where we have now resigned. We had designed that time beyond seas. We call that our empire extended beyond seas. हमारा जो चक्रवर्ती सम्राट था, चक्रवर्ती साम्राज्य था, वो समुद्रों के पार तक पहुंच गया, भारत इंडिया पहुंच गया, गल्फ में पहुंच गया, और जहां भी पहुंचा उन 3,000 कैदियों की वजह से, उन अपराधियों की वजह से पहुंचा जिनको हमने सजा दे रखी थी। और आप लोगों ने उनको मालाएं पहनाई, आप लोगों ने उनको कहा अतिदेव, व्हाट यू कॉल दैट, गेस्ट इज गॉड, खैर जो भी है, अतिथि देवो भव. Yes, अतिथि देवो भव. Atithi Deva Bhava, why am I expressing that guy did not say that. That guy asked me a question. In those days, many centuries back, you did not have gun or pistol or rifle. Why did you not shoot them? Those guys, those English guys who left our country, we pushed them out to beyond seas. Why you were enjoying with them? Why did you welcome them? Why did you give them food and residence and shelters and welcome them? What was the reason behind that? What intention did you have? You simply should have used your gun and killed them, and that's all. He said, don't blame us. If you slept, is it our fault? If you were sleeping that time, is it our fault? Why did you welcome them? Why you were not awake and some intruder has come, you should send him back. If he's a guest only for a few days, one should be guest or stay for the hour. अगर आप इतना भी नहीं समझते थे कि आपके देश में कोई बाहर का आदमी आया है और आपको मालाएं पहना रहे हैं, उसका स्वागत कर रहे हैं, अतिथि आए हैं, देव हैं, देवता हैं, तो आपकी गलती है या हमारी गलती? अगर देवता भी होता है तो 1-2 दिन के लिए होता है, 3 दिन के लिए होता है, सारी जिंदगी के लिए होता है? ये फैसला हमको करना था या आपको करना था? मेरे पास इस बात का जवाब नहीं, उत्तर नहीं था उस बूढ़े आदमी को बताने के लिए कि अब सही कह रहा था. वो सही कह रहा था. वो इसलिए कह रहा था ये बात कि उसने कहा था जिस 1947 को आपका झंडा लहराया गया, उस दिन बहुत दुख हुआ था कि देखिए ये लोग बर्बादी की तरफ जाएंगे, क्योंकि इनमें कॉमन सेंस नहीं. आपको चला नहीं सकते गाड़ी अपनी, ये खुद ये जानते नहीं कि गाड़ी कैसे चलाई जाती है और उसका नियंत्रण कैसे किया जाता है. इस बात को लेकर मुझे गुस्सा आया था, तभी मैंने उससे यह बात की थी. खैर जो भी रहा हो, वो आदमी अपनी जगह सही था. That man was right. He questioned and I had no answer at all. Why did we not shoot those criminals? It was whose fault? It was my fault, my father's fault, my father's father's fault, and grandfather's fault. That's fact of life. We have to recognize that. This means we accepted impurities, we accepted viruses into our soft Bharat, soft India. We were so soft, we used to sleep all time without even knowing who is coming, who is going. So we created all our problems and we are blaming others. Okay, that was question of British. Why did you allow others non-British before that? And before that we allow Aryans, or you can say Eurasians. Why? So one mistake, then another mistake, then another mistake, and mistake now. This is history, cannot be denied. Yes, stories can be fabricated, public can be misled, but whatever layers are there cannot be changed. You may speak wrong history, you may mislead people. Remember, truth is truth, truth is truth, Satyemev, Jyete. Again I say, you may expose, you may project 1 billion fake news, 1 billion false statements, but one truth acts as hydrogen bomb to destroy all those fakeism, all those fake news. एक सत्य अरबों खरबों झूठों के ऊपर भारी पड़ता है, जिस तरह एक शरीफ आदमी सैकड़ों बदमाशों के ऊपर भारी पड़ सकता है. क्योंकि शरीफ जब तक शरीफ है, जब तक सीधा साधा है, कुछ नहीं कर रहा, और जब उसकी आंख खुलेगी, होश आएगा, गुस्सा आएगा, तो हो सकता है 100 बदमाशों को वो इकट्ठा देख ले, एकदम देख ले. एक कहानी कहा जाता है, डायलॉग है. We have to see all this. We did so many mistakes in our lives, still we are doing. We have not learned anything. We say experienced persons learn from mistakes and learn from lessons. Lessons are there to learn from those mistakes, but we are not even learning any lesson because we are a sleeping society. I always call my country, we have been a sleeping society, and a sleeping society can never be a serious society. We are not serious because we have been sleeping. We sometimes get up in between just to take breakfast or food and then sleep. Then get up again and take some breakfast and food and then sleep. Sleeping doesn't mean physical sleep. Sleeping means mental sleeping. Awakening is not there. Those who are serious, it's difficult for them to sleep. but we have never been serious, and we cannot be serious if we keep ourselves as we are today. I'm not going to explain about whole history because I don't know all history. I'll just give you something which I came to know through various sources. That's not more that. It's very small, I'm telling you, and I don't know everything because I am a human being unlike you. I'm just trying to give a reference. Means why were we sleeping? Why had we been sleeping? Sleeping is very, very, you can say, difficult and dangerous state of mind, state of body. We want to get everything. We have to win all objectives and aims, but we don't know anything. Everybody thinks us have aspirations. I want to get this. I want to get this. Same way, nation has aspirations. Nation got aspirations. Aspirations, destinations, and milestones we have. We have what we want to do, but just having aim is not adequate. We must have fuel to get that. We must have fuel to start that engine of ambition so that we can reach our destination. But we don't have resources for that. We cannot even think of that. We can only talk of that. Talking doesn't mean anything. We can talk whatever we talk. Talking is too much. Poem expression is too much. Stories are too much. But we don't have facts. We don't have reality. We don't have a strong will to get that 1 milestone, 2 milestone, 3 milestones, whatever in sequence on that bar chart milestones available. We have to achieve all to get final milestone or destination and commission that and start that we don't have. हमारी बातें करने से क्या होता है? बड़ी बड़ी बातें सब करते आए करते रह रहे, हम भी कर रहे हैं, दूसरे भी करते हैं, नेता भी करते हैं, अभिनेता भी करते हैं. बातें करने से क्या होता है? बातें करने से कुछ नहीं होता है. यदि आपने जिंदगी में कुछ करना है तो कुछ करना है, खाली बातें करके कुछ नहीं मिलने वाला है. आपको सोचना पड़ेगा क्या करना है. आपको जिंदगी में अपना प्रोग्राम बनाना पड़ेगा, उसमें एक्टिविटीज डालनी पड़ेंगी, उसमें लिखना पड़ेगा कौन सा माइलस्टोन कब जो करना है. और जब सारे माइलस्टोन अचीव हो जाते हैं, प्राप्त कर लिए जाते हैं, तब मिलता है डेस्टिनेशन, तब मिलती है मंजिल. वो इमारत दिखती है, वहां पे बिल्डिंग भवन दिखता है वहां पे, जिसमें हमें रहना है, और वही हमारे साथ चलता है आगे, हमारे जीवन को बनाता है, निर्माण करता है. We have to see that building which we are going to construct, and that building is this nation. Building nation is very big, and it takes years and centuries and millenniums of some time, or it takes 500 years. America has not been fully till now for free for 4 or 5 centuries. So we have to keep this in our minds. Not simply हम ये नहीं कहना मैं सीखेंगे, क्या सीखेंगे? सीखो और करो. करो तो करो, नहीं करते तो सो जाओ. सोते ही तो रहते हैं हम, सोते ही तो. We have been sleeping society, and we're experts sleeping. We sleep too much, we cannot answer. One day I was talking to a doctor who is a very senior doctor somewhere working in this country. He was working outside also before, and he told me, I have a record of sleeping. He slept one time was 72 hours. Means here's a question of record of sleeping. We have been sleeping for centuries, for decades, and this is a record of sleeping. Bharat is a sleeping country, has been a sleeping country, and I don't want to see in future sleeping nation. We want to see the awakened nation, serious nation, working nations. We want to see that. That's very important. We were ruled till 1947 by British. This rule was not easy. I have downloaded गवर्नमेंट ऑफ इंडिया एक्ट 1935, भारत सरकार का अधिनियम 1935, जिसके कंट्रोल में हम थे, अंडर विच कंट्रोल वी वर गवर्नड till 1947. And then 1947 we got India Independence Act. I had discussed your last video. Half of that I had discussed, about 14 sections, and remaining I'll discuss today. But before that, I want to just inform, share with you, maybe because people don't go to history. Maybe many of you know about Government of India Act 1935. Generally, we know it's written many acts. When our Constitution refers to that one, that act has been repealed by virtue of this Constitution of Bharat, and Independent India Act 1947 also repealed. But repealing doesn't mean you cannot consider that. So that act is available, and you can see that act. This is India, Independence Act 1947, and then it is Government of India Act 1935, Government of India 1935, and Arrangements of sections. The section is the first part is introduction section, which says short title: Government of India by Crown, Governor General of India and His Majesty's representatives as regards relations with Indian states. Commander-in-Chief in India. Part 2 is Federation of India. Chapter, this is establishment of Federation and accession of India states. Then section 5 is Proclamation of Federation of India. Section 6, accession of Indian states. Then chapter 2 is Federal Executive, Governor General. Function 7, section 7, functions of Governor General. 8 is extent of executive authority of Federation and administration of federal affairs. Section 9, Council of Ministers, other provisions as to ministers. Then you can say there is section 11 is provisions as to defense, ecclesiastical affairs, external affairs, and tribal areas. Section 12, special responsibilities of Governor General, provisions as to instrument of instructions. Section 14, superintendence of Secretary of State. Section 15, financial advisor to Governor General. Section 16 is Advocate General for Federation. Section 17, conduct of business of federal government. It may be section or article doesn't mean federal legislature. It is now chapter 3, general. 18 says constitution of federal legislature. 19 sessions of legislature, prorogation and resolution. 20 right of Governor General to address and send messages to chambers. 21 rights of ministers, councillors and advocates general as respects chambers. 22 officers of chambers. 23 voting in chambers, power of chambers to act notwithstanding vacancies and quorum. Then member of legislatures. 24 oath of members. 25 is vacation of seats. 26 is disqualifications for membership. 27 is penalty for sitting and voting when not qualified or when disqualified. 28 is privileges and of members. 29 is salaries and allowance of members. Then legislative procedure. 30 is provisions as to introduction and passing of bills. 31 is joint sittings of both chambers in certain cases. 32 is assent to bills and power of Crown to disallow acts. Then 33 is financial matters regarding annual financial statement. We call it now budget. 34 is procedure in legislature with respect to estimates. 35 is authentication of schedule and authorized expenditure. 36 is supplementary statements of expenditure. 37 is special provision as to financial bills. And then procedures generally. 38 rules of procedures. 39 is English to be used in federal legislature. 40 is restrictions on discussion in legislature. 41 is courts not to inquire into proceedings of legislature. Chapter 4, legislative powers of Governor General. 42, power of Governor General to promulgate ordinances during recess of legislature. 43 is power of Governor General to promulgate ordinances at any time with respect to certain subjects. 44, power of Governor General in certain circumstances to enact acts. Chapter 5, provisions in case of failure of constitutional machinery, and this is 45, which is power of Governor General to issue proclamations. Then part 3, so Governor's provinces, chapter 1, provinces, and this 46, Governor's provinces. 47 is provisions as to where. Then chapter 2 is provincial executive governor. This is 48, appointment of governor, section 48. Section 49, executive authority of province. Then administration of provincial affairs. Section 50, council of ministers. Section 51, other provisions as to ministers. 52 is special responsibilities of governor. Section 53 is provisions as to instrument of instructions. 54 is superintendence of Governor General. Section 55 is Advocate General for province. 56 is provisions as to police rules. Section 57 is provisions as to crimes of violence intended to overthrow government. Section 58 is sources of certain information not to be disclosed. And Section 59, conduct of business of provincial government. And then provincial legislatures, Chapter 3, this is 60. Section 60, Constitution of Provincial Legislature. 61 is composition of chambers of provincial legislatures. 62 is sessions of legislative prorogation and dissolutions. Section 63, rights of governor to address and send messages to chambers. Section 64 is rights of ministers and advocate general as respects chambers. Section 65 is officers of chambers. Section 6 is voting in chambers, power of chambers to act notwithstanding vacancies and quorum. Then Section 67 is under provisions as to member of legislature. 67 is oath of members. 68 is vacation of seats. 69 is disqualifications for membership. Section 70 is penalty for sitting and voting when not qualified or when disqualified. Section 71 is privileges of members. 72 is salaries and allowances of members. Then legislative procedures. 73, introduction of bills. 74, passing of bills in provinces having legislative councils. 75, assent to bills. 76 is bills reserved for consideration. 77 is power of Crown to disallow acts. Then procedure in financial matters. 78 is annual financial statement. 79 is procedure in legislature with respect to estimates. 80 is authentication of schedule of authored expenditures. And 81 is supplementary statements of expenditure. 82 is special provisions as to financial bills. 83 is provisions with respect to certain educational grants. Then procedure general. 84 section is rules of procedure. 85 is English to be used in provincial legislatures. 86 is restrictions on discussion in legislature. 87 is courts not to inquire into proceedings of legislature. And chapter 4 is legislative powers of governor. 88 is power of governor to promulgate ordinances during a recess of legislature. 89 is power of governor to promulgate ordinances at any time with respect to certain subjects. And 90 is power of governor in certain circumstances to enact acts. And chapter 5 is excluded areas and partially excluded areas. Section 91 is exclusive areas and partially exclusive areas. Section 92 is administration of exclusive areas and partially exclusive areas. Then chapter 6, provisions in case of failure of constitutional machinery. And section 93 is power of governor to issue proclamations. Then part 4, chief commissioner of provinces. In section 94, chief commissioners of provinces. Section 95, British Balochistan. 96, Andaman and Nicobar Island. 97 is co-org. 98 is provisions as to police rules and as to crimes of violence intended to overthrow government. Then part 5 is legislative powers. Chapter 1 in that is distribution of powers. Section 99, extent of federal and provincial laws. 100 is subject matters of federal and provincial laws. 101 is extent of power to legislate for states. 102 is the power of federal legislature to legislate if an emergency proclaimed. And section 103, power of federal legislature to legislate for 2 or more provinces by consent. And section 104 is residual powers of legislation. And section 105, application of a Naval Discipline Act to the Indian and Naval Forces. And 106 is provisions as to legislation for giving effect to international agreements. And 109 is inconsistency between federal laws and the provincial or state laws. Then chapter 2 is regarding restrictions on legislative powers. 108 is sanction of Governor General or Governor required for certain legislative proposals. 109 is requirements as to sanctions and recommendations to be regarded as matters of procedure only. And 110 is savings. And in chapter 3, there is a chapter on the chapter. You have to keep this into consideration. I'm now This chapter is regarding this, what I'm talking about, the provisions with respect to discrimination are now 111 British subjects domiciled in the United Kingdom, 112 is taxation, and then 113 is companies incorporated in the United Kingdom, 114 is companies incorporated in India, 115 is ships and aircrafts, and 116 subsidies for encouragement of trade or industry, 117 is supplemental. 118 is power to secure reciprocal treatment by convention, and 119 is professional and technical qualifications in general. 120 is medical qualifications, and 121 is officers of Indian Medical Service, etc. And then part 6 is administrative relations between federation, provinces, and states. And in general is section 122 obligations. The sections are continuing in sequence. There's no change in between. So section 132 obligations of unit and federation. It's the obligation of unit and federation. 123 is Governor General may require governors to discharge certain functions as his agents. Now 124 is power of federation to confer powers on provinces and states in certain cases, and 125 administration of federal acts in Indian states. 126 is control of federation over province in certain cases. 127 is acquisition of land for federal purposes. 129 is duty of a ruler of a state as respects of federal subjects. Then is broadcasting. 129 section is broadcasting, then interference with water supplies. 130 section is complaints as to interference with water supplies. 131 is decision of complaints, and 132 is interference with water supplies of chief commissioners of province. 133 jurisdiction of courts excluded. 134 ruler of a state may exclude the application of provisions as to water supply inter-provincial cooperation. 135 provisions with respect to an interprofessional council. Then is part 7, which says finance, property, contracts, and suits. Chapter 1 on this finance, distribution of revenues between federation and federal units. Section 136, meaning of revenues of federal and revenue of province. 137 is certain succession duties, stamp duties, terminal taxes, and taxation of fares and freights. 138 is taxation on income. 139 is corporation tax. 140 is salt duties, excise duties, and export duties. 141 is a prior sanction of Governor General required to bills affecting taxation in which provinces are interested. 142 is grants from federation to certain provinces. 143 is savings. 144 is calculation of net proceeds, etc. And crowns and states related. 145 is expenses of crown in connection with Indian states. 146 is payments from or by Indian states. 147 remission of states contributions. 148 certain payments to federated states to be charged on the federal revenues. 149 the value of privileges and immunities to be set off against the shares of taxes assigned to federated states. And miscellaneous financial provisions are 150 accepted the expenditure defrayable out of Indian revenues. Section 151 the provisions as to custody of public monies. 152 is exercised by Governor General of certain powers with respect to Reserve Bank. 153 section provisions previous sanctions of Governor General to legislation with respect to Reserve Bank currency and coinage. Then you go to section 150 for exemption of certain public property from taxation. 151 exemption of provincial governments and rules of federated states in respect of federal taxation. 156 adjustment in respect of certain expenses and pensions. 157 duties of federation and provinces to supply secretary of state and funds. 158 the provisions as to relations of Burma monetary system with India. 159 relief in respect of a tax on income taxable both in India and Burma. 160 the provisions as to customs duties on India-Burma trade. Chapter 2 in this is the borrowing and audits, and this is borrowing regarded related. 161 section cessation of borrowing by secrecy or Secretary of State and Council. 162 is borrowing by federal government. 163 is borrowing by provincial governments. 164 is loans by federal governments to federated states. Then 165 is application of colonial stock access to stocks issued by federation. Audit and accounts, section 166, the Auditor General of India. 167, the Provincial Auditor General. 168, the power of Auditor General of India to give directions as to accounts. 169 is audit reports. 170 is auditor of Indian Home Accounts. 171 is audit of accounts relating to discharge of functions of Crown in relation to Indian states. And then chapter under this is chapter 3, property, contracts, liabilities and suits. 172 vesting of lands and buildings. 173 provisions as to other property. 174 the property accruing by escheats or lapses or as bona vacantia. Then section 175 power to acquire property and to make contracts. 176 suits and proceedings. 177 existing contracts of secrecy of state in the council. 178 is special provisions as to existing loans, guarantees and other financial obligations. 179 is legal proceedings as to certain matters. 180 is contracts in connection with functions of Crown in its relations with Indian states. Then part 8, Federal Railway Authority. Section 181, executive authority in respect of railways to be exercised by Federal Railway Authority. 182 composition etc. for Railway Authority. 183 is directions and principles to be observed by Railway Authority. 184 is conduct of business between Railway Authority and Federal Government. Number 185 is acquisition and sale of land contracts and working agreements. 186 is finance of the Railway Authority. 187 is provisions as to certain obligations of Railway Authority. 188 is investment of funds of Railway Authority. 189 is special provisions as to certain existing funds. 190 is audit and annual reports. 191 Railway Rates Committee. 192 is bills and amendments for regulating rates and fares to require recommendations of Governor General. 193 is obligations of Railway Authority and Federated States to afford the mutual traffic facilities and to avoid unfair discrimination, etc. 194 appeal by state to Railway Tribunal from certain directions of Railway Authority. 195 is construction and reconstruction of railways. 196 is Railway Tribunal. 197 is rights of railway companies in respect of arbitration under contracts. 198 railways in Indian states which have not federated. 199 official directors of Indian railway companies. Then part 9, judiciary or judicature. Chapter 1, Federal Court. Section 200, establishment and constitution of Federal Court. 201 is salaries of judges. 203 temporary appointment of acting Chief Justice. 203 seat of Federal Court. 204 original jurisdiction of Federal Court. 205 is appellate jurisdiction of Federal Court in appeals from high courts in British India. 206 is power of federal legislature to enlarge appeal jurisdiction. 207 appellate jurisdiction of Federal Court in appeals from high courts in federated states. 208 is appeals to His Majesty in Council. 209 is a form of judgment on appeal. 210 is enforcement of decrees and orders of Federal Court and orders as to discovery. And then 211 is letters of request to federated states. 212 is law declared by Federal Court and Privy Council to be binding on all courts. Then 213 power of Governor General to consult to Federal Court. 214 is rules of court. 215 is ancillary power of Federal Court. 216 is expenses of Federal Court. 270 is construction of references to high courts in states. 218 is saving. Then chapter 2 into this high courts in British India. 219 meaning of high court. 220 constitution of high courts. 221 salaries of judges. 222 temporary and additional judges. 223 jurisdiction of existing high court. 224 administration functions of high courts. 225 transfer of certain cases to high court for trial. 226 jurisdiction and revenue matters. 227 is proceedings of high courts to be in English. Then section 228 expenses of high court. 229 power of His Majesty to constitute or reconstitute high court by letters of patent. 230 extra provincial jurisdiction of high court, savings and definition. 231. Then part 10 of this law, the statute, is services of Crown of India. Under this chapter 1, defense services. 232 pay of commander-in-chief. 233 control of His Majesty as to defense appointments. 234 eligibility for commissions in Indian Forces. 235 control of Secretary of State with respect to conditions of service. 236 savings of rights of appeal. 237 pay of members of forces to be charged on federal revenues. 238 provisions as to certain civilian personnel. 239 King's India cadetships. Chapter 200 is civil services, general provisions. Section 240 tenure of office of persons. employed in civil capacities in India. 241 recruitment and conditions of service. 242 the applications of preceding sections to railway, customs, postal and telegraph services and officials of courts. 243 special provisions as to police. Recruitment by Secretary of State and provisions as to certain posts. Section 244 services required recruited by Secretary of State. 245 special provisions as to irrigation. 246 result posts. 247 conditions of service, pensions, etc. of persons recruited by Secretary of State. 248 rights in respect of complaints, appeals, etc. 249 compensation. And now provisions as to persons appointed by Secretary of State in Council, persons holding a reserved post and commission officers in civil employment. Section 250 is application of 4 last preceding sections to persons appointed by Secretary of State in Council and certain other provisions. Special provisions as to staff of High Commissioner for India and a auditor of India Home Accounts. 251 staff of High Commission and auditor of Indian Home Accounts. 252 conditions of service of existing staff of High Commissioner and auditor of Indian Home Accounts. Then special provisions as to judicial officers, section 253, judges to federal court and high courts. 254 district judges. 255 subordinate civil judicial service. 256 subordinate criminal magistracy. And special provisions as to political department. Section 257 officers of political department, and provisions for protection of certain existing officers. Section 258 provisions for protection of existing officers of certain services. And section 259 provisions as to certain persons serving in or before 1924. 260 general provisions as to persons retiring before commencement of part 3. Then miscellaneous are section 261 Secretary of State to act with concurrence of his advisors. 262 eligibility for office of persons who are not British subjects. 263 joint services and posts. Then chapter 3 public service commissions. Section 264 Public Service Commission. 265 Composition and Staff of Commission. 260 Functions of Public Service Commission. 267 Power to extend functions of Public Service Commission. 268 Expenses of Public Service Commission. Then chapter 4 Chaplains. 269 provisions as to chaplains. Then chapter 5 General. Is 270 Indemnity of past acts. 271 Protection of public servants against the prosecutions and suits. 270 is provisions as to payment of certain pensions and exemptions of those pensions from taxation in India. 273 provisions as to family pensions fund. 274 is savings for certain funds acts. 275 is persons are not to be disqualified by sex for holding certain offices. 276 is transitional provisions. 277 interpretation. And part 6 Secretary of State, his advisors and his department. Section 278 advisors to Secretary of State. 279 existing accounts of Secretary of State in Council with the Bank of England. 280 is organization and expenses of India offices. 281 is transfer of existing personnel. 282 is the contributions from revenues of a federation. 282 is a liability by pensions, liability for pension in the respect of a service before commencement of part 3. 284 provisions as to certain India office provident funds. Then part 12 miscellaneous and general, Crown and Indian States. Section 285 savings for rights and obligations of Crown in its relations with Indian States. 286 is use of His Majesty's forces in connection with discharge of functions of Crown in its relations with Indian States. 287 arrangements for governance and provincial staff to assist in discharging functions of political department. And then add-on, section 280 is add-on, new provinces and alterations of boundaries of provinces. 289 is creation of new provinces of Sindh and Orissa. 290 is creation of new provinces and alterations of boundaries of provinces. Franchise. Section 291, power of His Majesty to make provisions with respect to franchise and elections, and provisions as to certain legal matters. Section 292, existing law of India to continue in force. 293, adaptations of existing Indian laws. 294, foreign jurisdiction. 295, provisions as to death sentence, 296 the course of appeal in the revenue matters, 297 prohibitions of certain restrictions on internal trade, 298 is persons not to be subjected to disability by reasons of race, religion, etc. 299 is compulsory disqualification of land, 300 protection for certain rights, privileges and pensions, 301 repeal of section 118 to 21 and various others. High Commissioner 302, High Commissioner for India, General Provisions 303, provisions as to Sheriff of Calcutta, 304 persons acting as Governor General or Governor, and then 305 Secretarial Staff of Governor General and Governor, 306 the protection of Governor General, Governor or Secretary of State, 307 removal of certain disqualifications on occasions of first elections to legislature, 308 the procedure as respects proposals for amendments of certain provisions of Act and orders in Council, 309 order in Council, 310 power of His Majesty in the Council to remove difficulties and interpretation, 311. Then part 13 transitional provisions, 312 operation of part 13, 313 executive government, 314 control of Secretary of State, 315 sterling loans, 316 legislature, 317 continuance of certain provisions of Government of India Act, 318 is provisions as to federal court and certain other federal authorities, 319 is rights and liabilities of Governor General in Council and Governor General to continue after establishment of federation. Then part 14, commencement repeals, 320 commencement, 321 repeals and schedules. First schedule composition of federal legislature, second schedule provisions of this act which may be amended without affecting accession of states, then schedule continue, third schedule provisions as to Governor General and Governor of provinces, fourth schedule forms of oaths or affirmations, fifth schedule comparisons of provincial legislatures, sixth schedule is provisions as to franchise, seventh schedule is legislative list, and eighth schedule Federal Railway Authority, ninth schedule is provisions of Government of India Act continued in force with amendments until the establishment of federation, 10th schedule enactments repealed. So this was content index of this act, Government of India Act 1935. So now chapter 2 starts, and we just briefly see. I cannot go through all pages, but just try to tell you important things on that, so that at least you must know what was that act after which you got independence. This act continued in 1947, and title of this act is an act to make further provisions, an act to make further provisions for Government of India, and that is on 2nd August 1935, date of this publication act, 2nd August 2 August 1935, 2nd is 1935, and what it says, be it enacted by King's Most Excellent Majesty, be it enacted by King's Most Excellent Majesty, by and with advice and consent of lords, spiritual and temporal, and commons in this present Parliament assembled, and by authority of same as follows. Part 1, introductory, I'll just speak with that. This act may be cited as Government of India Act 1935 with a short title. Section 2, all rights, authority and jurisdiction hereto for belonging to His Majesty King Emperor of India, which appertain or are incidental to government of territories in India for time being vested in him, and all rights, authority, and jurisdiction exercisable by him in or in relation to any other territories in India are exercisable by His Majesty except in so far as may be otherwise provided by or under this act, or as may be otherwise directed by His Majesty, provided that any power connected with exercise of functions of Crown in its relations with Indian states shall in India, if not exercised by His Majesty, be exercised only by or by persons acting under authority of His Majesty's representative for exercise of those functions of Crown. Then it says further, said rights, authority and jurisdiction shall include any rights, authority or jurisdiction heretofore exercisable in or in relation to any territories in India by Secretary of State. Secretary of State in Council, Governor General, Governor General in Council, any governor or any local government, whether by delegation from His Majesty or otherwise. Then Section 3. Governor General of India is appointed by His Majesty by commission under royal sign manual and has as such all such powers and duties as are concerned and imposed on him by under this Act, such other powers of His Majesty not being powers connected with exercise of functions of Crown in its relations with Indian states or as His Majesty may be pleased to assign to him. And His Majesty's representative for exercise of functions of Crown in its relations with Indian states is appointed by His Majesty in like manner and has such powers and duties in connection with exercise of those functions not being powers or duties conferred or imposed by or under this Act on Governor General, as His Majesty may be pleased to assign to him. It shall be lawful for His Majesty to appoint one person to fill both said offices. There shall be a Commander-in-Chief of His Majesty's forces in India appointed by warrant under Royal Sign Manual. Federation of India. Go to Section 5. It shall be lawful for His Majesty, if an Indian address in that behalf has been presented to him by each House of Parliament, and if condition here and after mentioned is satisfied, to declare by proclamation that as from that day therein appointed there shall be united in a federation under Crown by the name of Federation of India, provinces hereafter called governors, provinces, Indian states which have acceded or many thereafter accede to federation, and federation should establish there shall be included provinces hereafter called chief commissioners provinces. Condition referred to is that states rulers whereof will in accordance with provisions contained in Part 2 of first schedule to this Act be entitled to choose not less than 52 members of Council of State, aggregate population thereof as ascertained in accordance with said provisions amounts to at least one half of total population of states as to ascertained have acceded to federation. 6. Accession of Indian states. A state shall be deemed to accede to federation of His Majesty has signed his acceptance of an instrument of accession executed by ruler thereof, whereby ruler for himself has heirs and successors, declares that he accedes to federation as established under this Act with intent that His Majesty the King, Governor General of India, Federation General, Federal General, the Federal Court, and any other federal authority established for purposes of federation shall by virtue of the legislature of his instrument of accession, but subject always to terms thereof, and for purpose only to federation exercise in relation to this state such functions as may be vested in them by or under this Act, and assumes obligations of ensuring that due effect is given within his state to provisions of this Act so far as they are applicable therein by virtue of this instrument of accession. Provided that an instrument of accession may be executed conditionally on establishment of federation on or before specified date, and in that case, the state shall not be deemed to have acceded to federation if federation is not established until after that date. An instrument of accession shall specify matters which ruler accepts as matters with respect to which federal legislature may make laws for state, and limitations, if any, to which powers of federal legislature to make laws for his state, and exercise of executive authority of a federation in his state are respectively to be subject. A rural may buy a supplementary instrument executed by him and accepted by His Majesty vary instrument of accession of his state by extending functions which by virtue of that instrument are exercisable by His Majesty or any federal authority in relation to the state. Nothing in this section shall be construed as requiring His Majesty to accept any instrument accession or supplementary instrument unless he considers it proper so to do, or as empowering His Majesty to accept any such instrument if it appears to him that terms thereof are inconsistent with scheme of federation embodied in this Act. Provided that after establishment of federation, if any instrument has in fact been accepted by His Majesty, validity of instrument or of any of its provisions shall not be called in question, and provisions of this Act shall in relation to state have effect subject to provisions of this instrument. It shall be in term of every instrument of accession that provisions of this Act mentioned in second schedule thereto may, without affecting accession of state, be amended by or by authority of Parliament, but no such amendment shall, unless it is accepted by ruler in supplementary instrument, be construed as extend functions which by virtue of instrument are exercisable by His Majesty or any federal authority in relation to state. An instrument of accession or supplementary instrument shall not be valid unless it is executed by a ruler himself, but subject, as aforesaid, references in this Act to ruler of state include reference to any person for time being exercising power of ruler of state, whether by reason of ruler's minority or for any other reason. After establishment of federation, request of a ruler that his state may be admitted to federation shall be transmitted to His Majesty through Governor General, and after expiration of 20 years from establishment of federation, Governor General shall not transmit to His Majesty any such request until there has been presented to him by each member of federal legislature for a submission to His Majesty, an address praying that His Majesty may be pleased to admit state into federation. In this Act, a state which has acceded to federation is referred to as a federated state, and instrument by virtue of which a state has so acceded, construed together with any supplementary instrument executed under this section is referred to as instrument of accession of that state. As soon as may be after an instrument of accession or supplementary instrument has been accepted by His Majesty under this section, copies of instrument and of His Majesty's acceptance thereof shall be laid before Parliament, and all courts shall take judicial notice of every such instrument and acceptance. Chapter 2. In the same, Federal Executive Governor General, Section 7A, subject to provisions of this Act, executive authority of federation shall be exercised on behalf of His Majesty by Governor General, either directly or through officers subordinate to him, but nothing in this section shall prevent federal legislature from conferring functions upon subordinate authorities or with him to transfer to Governor General any function conferred by any existing Indian law on any court, judge or officer or any local or other authority. References in this Act to functions of Governor General shall be construed as references to his powers and duties in exercise of executive authority of Federation and to any other powers and duties conferred or imposed on as Governor General by or under this Act other than powers exercisable by him by reason that they have been assigned to him by His Majesty under Part 1 of this Act. Then 3. Provision of third schedule to this Act shall have effect with respect to salary and allowances of Governor General and provisions to be made for enabling him to discharge conveniently and with dignity duties of his office. 8. Subject to provisions of this Act, executive authority of Federation extend to matters with respect to which federal legislature has power to make laws. 2. Raising on British India on behalf of His Majesty of naval, military and air force and to governance of His Majesty's forces born on Indian establishment. The exercise of such rights, authority, and jurisdiction as are exercisable by His Majesty by treaty, grants, uses, sufferance, or otherwise in relation to tribal areas, provided that said authority does not save, as expressly provided in this Act, extend in any province to matters with respect to which provincial legislature has power to make laws. Said authority does not save, as expressly provided in this Act, extend in any federated state, save to matters with respect to which federal legislature has power to make laws for that state, and exercise thereof in each state shall be subject to such limitations, if any, as may be specified in instrumentalization of state. Said authority does not extend to enlistment or enrollment or in any forces raised in India of any person unless he is either a subject of His Majesty or a native of India or territories adjacent to India. Commissions in any such force shall be granted by His Majesty, save insofar as he may be pleased to delegate that power by virtue of provisions of Part 1 of this Act or otherwise. Executive authority of ruler of federated state shall notwithstanding anything in this section continue to be exercisable in that state with respect to matters with respect to which federal legislature has power to make laws for that state, except insofar as executive authority of federation becomes exercisable in state to exclusion of executive authority of ruler by virtue of a federal law. Administration of Federal Affairs. Section 9. There shall be a council of ministers. See, there shall be a council of ministers not exceeding 10 in number to aid and advise Governor General in exercise of his functions, except insofar as he is by or under this Act required to exercise his functions or any of them in his discretion. And provided that nothing in this subsection be construed as preventing Governor General from exercising his individual judgment in any case whereby or under that Act he is required so to do. Then Governor General in this discretion may preside at meetings of Council of Ministers. Then if any question arises whether any matter is or is not a matter as respects which Governor General is by or under this Act required to act in his discretion or to exercise his individual judgment, decision of Governor General in his discretion shall be final, and validity of anything done by Governor General shall not be called in question on ground that he ought or ought not to have acted in his discretion or ought not to have exercised his individual judgment. 10. Governor General's ministers shall be chosen and summoned by him, shall be sworn as members of council, and shall hold office during his pleasure. A minister who for any period of 6 consecutive months is not a member of either chamber of federal legislature shall, at expiration of that period, cease to be a member. Salaries of ministers shall be such as federal legislature may from time to time by act determine, and until federal legislature so determines shall be determined by Governor General, provided the salary of a minister shall not be varied during his term of office. Question whether any and if so, what advice was tendered by ministers to Governor General shall not be inquired into any court. Functions of Governor General with respect to choosing and summoning and dismissal of ministers and with respect to determination of their salaries shall be exercised by him in his discretion. 11. Functions of Governor General with respect to defense and ecclesiastical affairs and with respect to external affairs, except relations between Federation and any part of His Majesty's dominions, shall be exercised by him in his discretion, and his functions in or in relation to tribal areas shall be similarly exercised. To assist him in exercise of those functions, Governor General may appoint councillors not exceeding 3 in number, whose salaries and conditions of service shall be such as may be prescribed by His Majesty in council. 12. Exercise of his functions, Governor General shall have following special responsibilities, that is to say, prevention of any grave menace to peace or tranquility of India or any part thereof, safeguarding of financial stability and credit of federal government, safeguarding of legitimate interests of minorities, safeguarding of legitimate interests of minorities, securing to and to dependents of persons who are or have been members of public service of any rights provided or preserved for them by under this act, and safeguarding of their legitimate interests. Securing in sphere of executive action of a purpose which provisions of Chapter 3 of Part 5 of this Act are designed to secure relations to legislature. Prevention of action which would subject goods of United Kingdom or Burmese origin imported into India to discriminatory or penal treatment. Protection of rights of any Indian state and rights and dignity of rural thereof, securing that due discharge of his function with respect to matters with respect to which he or by or under this act required to act in his discretion or to exercise his individual judgment is not prejudiced or impeded by any course of action taken with respect to any other matters. If and insofar as any special responsibility of Governor General is involved, he shall, in exercise of his functions, exercise his individual judgment as to action to be taken. Section 13. Secretary of State shall lay down before Parliament draft of any instrument or instruction, including any instrument amending or revoking an instrument previously issued, which it is proposed to recommend His Majesty to issue Governor General to Governor General and no further proceedings shall be taken in relation thereto, except in pursuance of an address presented to His Majesty by both Houses of Parliament, praying that instrument may be issued. Validity of anything done by Governor General shall not be called in question on ground that it was done otherwise than in accordance with any instrument of instructions issued to him. 14. Insofar as Governor General is by or under this Act required to act in his discretion or to exercise his individual judgment, he shall be under general control of and comply with such particular directions, if any, as many from time to time be given to him by Secretary of State, but validity of anything done by Governor General shall not be called in question on grounds that it was done otherwise than in accordance with provisions of this section. Before giving any of these directions under this section, Secretary of State shall satisfy himself that nothing in this direction requires Governor General to act in any manner inconsistent with any instrument of instructions issued to him by His Majesty. 15. Governor General may appoint a person to be his financial advisor. It shall be duty of Governor General's financial advisor to assist by his advice Governor General in discharge of his special responsibility for safeguarding financial stability and credit of federal government, and also to give advice to federal government upon any matter relating to finance with respect to which he may be consulted. Governor General's financial advisor shall hold office during pleasure of Governor General, and salary and allowances of financial advisor and number of his staff and their conditions of service shall be such as Governor General may determine. Powers of Governor General with respect to appointment and dismissal of a financial advisor, and with respect to determination of his salary and allowances and numbers of his staff and their conditions of service shall be exercised by him in this discretion. Provided that if Governor General has determined to appoint a financial advisor, he shall, before making any appointment other than first appointment, consult his ministers as to person to be selected. Governor General shall appoint a person, being a person qualified to be appointed the judge of federal court, to be advocate general for that federation. It shall be duty of advocate general to give advice to federal government upon such legal matters and to perform such other duties of a legal character as may be referred to or assigned to him by Governor General. And in the performance of his duty, he shall have right of audience in all courts in British India, and in a case in which federal interests are concerned, in all courts in any federated state. Advocate General shall hold office during pleasure of Governor General and shall receive such remunerations as Governor General may determine. In exercising his powers with respect to appointment and dismissal of Advocate General and with respect to determination of his remuneration, Governor General shall exercise his individual judgments. Section 17. All executive actions of federal government shall be expressed to be taken in name of Governor General. Order and other instruments made and executed in name of Governor General shall be authenticated in such manner as may be specified in rules to be made by Governor General, and validity of an order or instrument which is so authenticated shall not be called in question on ground that it is not an order or instrument made or executed by Governor General. Governor General shall make rules for more convenient transaction of business of federal government and for allocation among ministers of said business insofar as it is not business with respect to which Governor General is by or under this Act required to act in his discretion. Rules shall include provisions requiring ministers and secretaries to government to transmit to Governor General all such information with respect to business of federal government as may be specified in rules, or as Governor General may otherwise require to be so transmitted, and in particular requiring a minister to bring to notice of Governor General, an appropriate secretary to bring to notice of minister concerned and of Governor General any matter under consideration by him which involves or appears to him likely to involve any special responsibility of Governor General. In discharging of his functions under subsection 234 of this section, Governor General shall act in his discretion after consultations with ministries. Federal Legislature, Section 18. There shall be a federal legislature which shall consist of His Majesty represented by Governor General and two chambers to be known respectively as Council of States and House of Assembly in this Act, referred to as Federal Assembly. It was Federal Assembly, okay. Council of States shall consist of 156 representatives of British India and not more than 104 representatives of Indian states, and Federal Assembly shall consist of 250 representatives of British India and not more than 125 representatives of Indian states. Said representatives shall be chosen in accordance with provisions in that behalf contained in first schedule to this Act. Council of State shall be permanent body, not subject to dissolution, but as near as may be 1/3 of members thereof shall retire in every third year, in accordance with provisions in that behalf contained in said first schedule. Every Federal Assembly, unless sooner dissolved, shall continue for 5 years from date appointed for their first meeting and no longer, and expiration of said period of 5 years shall operate as a dissolution of Assembly. Section 19. Chamber of Federal Legislature shall be summoned to meet once at least in every year, and 12 months shall not intervene between their last sitting in one session and date appointed for their first sitting in next session. Subject to provisions of this section, Governor General may, in his discretion, from time to time, summon chambers of either chamber to meet at such time and place as he thinks fit, prorogue chambers, dissolve Federal Assembly. Chambers shall be summoned to meet for their first session on a day not later than such days as be specified in their behalf in His Majesty's Majesty's Proclamation, Establishment, Federation. 20. Governor General may, in his discretion, address as either chamber of Federal Legislature or both chambers assembled together and for that purpose require attendance of members. Governor General may, in his discretion, send messages to either chamber of federal legislature, whether with respect to and will then. Governor General may, in his discretion, send message to either chamber of federal legislature, whether with respect to bill then pending in legislatures or otherwise, and the chamber to whom any messages is to send shall with all convenient dispatches consider and make matter which they are required by message to take into consideration. Every minister, every councillor and advocate general shall have right to speak in and otherwise to take part in proceedings of either chamber, any joint sittings in the chambers and any committee of legislatures of which he may be named a member, but shall not by virtue of this section be entitled to vote. Council of State shall as soon as may be chosen may choose two members of council to be respectively president and deputy president thereof. And so often as office of president or deputy president becomes vacant, council shall choose another member to be president or deputy president as case may be. Member holding office as president or deputy president of Council of States shall vacate his office if he ceases to be member of council, may at any time resign his office by writing under his hand address to Governor General, and may be removed from his office by a resolution of council passed by majority of all then members of council. But no resolution for purpose of this subsection shall be moved unless at least 14 days notice been given of intention to move resolution. While office of president is vacant, duties of office shall be performed by deputy president, or if office of deputy president is also vacant, by such member of council as Governor General may in his discretion appoint for purpose. And during any absence of president from any sitting of council, deputy president, or if he is also absent, such person as may be determined by rules of procedure of council, or if no such person is present, such other person as may be determined by council shall act as president. There shall be paid to president and deputy president of council of states such salaries as may be respectively fixed by act of federal legislature, and until provisions in this behalf so made, such salaries as Governor General may determine. Foregoing provisions of this section shall apply in relation to Federal Assembly as they apply to relation to Council of State, with substitution of titles Speaker and Deputy Speaker. For titles President and Deputy President respectively, and with substitution of references to Assembly for references to Council, provided without prejudice to provisions of subsection 2 of this section as applied by this subsection. Whenever Assembly is dissolved, Speaker shall not vacate his office until immediately before first meeting of Assembly after dissolution. To say section 30, save as provided in last preceding section, all questions at any sitting or joint sitting of chambers shall be determined by a majority of votes of members present and voting other than President or Speaker or person acting as such. President or Speaker or person acting as such shall not vote in first instance but shall have and exercise a casting vote in case of an equality of voters. A chamber of federal legislature shall have power to act notwithstanding any vacancy in membership thereof and any proceedings in legislature shall be valid. I'll read it again. This is 2. A chamber of federal legislature shall have power to act notwithstanding any vacancy in membership thereof, and any proceedings in legislature shall be valid notwithstanding that it is discovered subsequently that some person okay. If at any time during a meeting of chamber less than 1/6 of total number of members of chamber are present, it shall be duty of president or speaker or person acting as such either to adjourn chamber or to suspend meeting until at least 1/6 of members are present. Provisions as to member of legislature 24. Every member of either chamber shall, before taking his seat, make an unsubscribed before Governor General or some person appointed by him on oath according to that one of forms set out in fourth schedule to this act which membership for this member accepts it. Fourth schedule to this act which the member accepts is appropriate in his case. 25. No person shall be a member of both chambers, and rules made by Governor General exercising his individual judgment shall provide for fornication by a person who is chosen a member of both chambers of a seat as one chamber or other. If a member of either chamber becomes subject to any of disqualification mentioned in subsection of next to succeeding section by writing under his hand addressed to Governor General resigns his seat. His seat shall thereupon become vacant. If for 60 days a member of either house, either chamber is without permission of chamber absent from meetings thereof, chamber may declare his seat vacant. If for 60 days it is, provided that in completing 60 period of days, provided that in computing said period of 60 days, no account shall be taken of any period during which chamber is prorogued or is actually okay. Wait a minute. Provided that in computing said period of 60 days, no account shall be taken of any period during which chamber is prorogued or is injustice. Let me read it again. Provided that in computing said period of 60 days, no account shall be taken of any period during which chamber is prorogued or is adjourned for okay. Liable to any proceedings in court. Leave it now. I'll go to some other. In other prospects, the privileges of members of chambers shall be such as may from time to time be defined by act of federal legislature, and until so defined shall be such as were immediately before establishment of federal enjoyed by members of Indian legislature. Notwithstanding any existing Indian Act and notwithstanding anything in foregoing provisions of this section, nothing in this act shall to, okay. Nothing in this existing Indian Act, notwithstanding anything in foregoing provisions of this section, nothing in this section shall be construed as conferring or empowering federal legislature to confer or on either a chamber. All right. Notwithstanding any existing Indian Act and notwithstanding anything in foregoing provisions of this section, nothing in this act shall be construed as conferring or empowering federal legislature to confer on either a chamber or common or both chambers sitting together or in any committee or a officer of. Okay. Now I'll move to some other important because this, and that is salaries, etc. Nothing to do with that. Forget that. Legislative procedure. Let us take a look on that. It's been brief because I cannot go through all whole document, which is a very long document. You can download from URL given or some other one, and you go through that yourself better because I'm just giving a reference with what happened in those days. Section 30 subject to special provisions of this part of this act with respect to financial bills. A bill may originate in either chamber, which is subject to provisions of next succeeding section. A bill shall not be deemed to have been passed by chambers of legislatures unless it has been agreed to by both chambers, either without amendment or with such amendments. A bill pending in legislature shall not lapse by reason of prorogation of chambers. A bill pending in the Council of States which has not been passed by a Federal Assembly shall not lapse on dissolution of Assembly. A bill which is pending in Federal Assembly on which having been passed by Federal Assembly is pending in Council of States. Okay. Now I'll go to joint sittings of bad chamber. Leave this one. What I mean to say, if there's some important, I'll let you know. It's important. This when a bill is passed, bill the power of crown to disallow acts. All right, this is something. When a bill, this section 32, when a bill has been passed by chambers, it shall be presented to Governor General, and Governor General shall, in his discretion, declare either that assents in his Majesty name to bill or that those assist the whole. This is well. Financial matters will not pick up procedures and decisions with respect to estimates. Leave this all. No need. We're not talking budget. Authentication of schedule for expenditure. Section 35. Governor General shall authenticate by signatures a schedule specifying grant made by chambers under last proceedings sections. Several sums required to meet expenditures incurred. Okay, so we'll move further. 36 is supplementary statements on expenditure. Okay. Well, this is moving further and in English to be used in federal legislature. 39, all proceedings in federal legislature. This mean, all proceedings in federal legislature shall be conducted in English language, provided that rules of procedure of each chamber and rules with respect to joint sittings shall provide for enabling persons unacquainted or not sufficiently acquainted with English language to use another language. Okay, now what I'm finding something here that before going further, I have to just change. You have to listen to one I say. You have to listen to one, you can say, YouTube video that I'm going to put in regarding India Independence Act. YouTube, I'm just going to this video I am just going to put in for your hearing. I cannot show it directly, and you just listen to that before we talk further on this act and another act, which is very, you may at least know background of India Independence Act 1947.
The Indian Independence Act 1947 was as an act of the Parliament of the United Kingdom that partitioned British India into the two new independent dominions of India and Pakistan. The Act received the royal assent on July 18, 1947, and Pakistan came into being on August 14th, and India on August 15th, as two new countries. The legislation was formulated by the government of Prime Minister Clement Attlee and the Governor-General of India Lord Mountbatten, after representatives of the Indian National Congress, the Muslim League, and the Sikh community came to an agreement with the Viceroy of India, Lord Mountbatten of Burma, on what has come to be known as the 3rd June Plan or Mountbatten Plan. The background to the Act, Applet Euro Unregistered Trademark S announcement. The Prime Minister of the United Kingdom announced on February 20, 1947 that British government would grant full self-government to British India by June 1948 at the latest. The future of princely states would be decided after the date of final transfer is decided. June 3rd Plan. This was also known as the Mountbatten Plan. The British government proposed a plan announced on June 3, 1947 that included these principles. Principle of partition of India was accepted by the British government. Successor governments would be given dominion status. Implicit right to secede from the British Commonwealth. The Indian Independence Act 1947 was the implementation of June 3rd Plan. The Act's provisions. The Act's most important provisions were division of British India into the two new and fully sovereign dominions of India and Pakistan, with effect from August 15, 1947. Partition of the provinces of Bengal and Punjab between the two new countries. Establishment of the office of Governor-General in each of the two new countries, as representatives of the Crown. Conferral of complete legislative authority upon the respective constituent assemblies of the two new countries. Termination of British suzerainty over the princely states, with effect from August 15, 1947, and recognized the right of states to accede to either dominion. Abolition of the use of the title Emperor of India by the British monarch. The Act also made provision for the division of joint property, etc. between the two new countries, including in particular the division of the armed forces. Salient features of the Act: two new dominions were to emerge from the Indian Union, Pakistan and India. Appointed date: August 15, 1947 was declared as the appointed date for the partition. Territories: Pakistan, East Bengal, West Punjab, Sindh, and Chief Commissioner Unregistered Trademark S Province of Balochistan. The fated Northwest Frontier Province was subject to the result of referendum. Bengal and Assam. The province of Bengal as constituted under the Government of India Act 1935 ceased to exist. In lieu thereof, two new provinces were to be constituted, to be known respectively as East Bengal and West Bengal. The fated district Sylhet, in the province of Assam, was to be decided in a referendum. Punjab, the province as constituted under the Government of India Act 1935 ceased to exist. Two new provinces were to be constituted, to be known respectively as West Punjab and East Punjab. The boundaries of the new provinces were to be determined by, whether before or after the appointed date, by the award of a boundary commission to be appointed by the Governor-General. Constitution for the new dominions. Until the time of framing of new constitution, the new dominions and the provinces thereof were to be governed by the Government of India Act 1935. The Governors-General of the new dominions, for each of the new dominion a new Governor-General was to be appointed by the Crown, subject to the law of the legislature of either of the new dominions. Same person as Governor-General of both dominions, if unless and until provision to the contrary was made by a law of the legislature of either of the new dominions, the same person could be the Governor-General of both. Powers of Governor-General. The Governor-General was empowered to bring this act in force. Division of territories, powers, duties, rights, assets, liabilities, etc., was the responsibility of Governor-General to adopt, amend, Government of India Act 1935, as the Governor-General may consider it necessary. Power to introduce any change was until March 31, 1948, after that it was open to the Constituent Assembly to modify or adopt the same act. Governor-General had full powers to give assent to any law. Legislation for the new dominions. The existing legislative setup was allowed to continue as constitution-making body as well as a legislature. The legislature of each dominion was given full powers to make laws for that dominion, including laws having extraterritorial operation. No Act of Parliament of UK passed after the appointed date would be extended to the territories of new dominions. No law and provision of any law made by the legislature of the new dominions shall be void or inoperative on the ground that it is repugnant to the law of England. The Governor-General of each dominion had full powers to give assent in his Majesty Unregistered Trademark S name to any law of the legislature. Configuration of Pakistani Unregistered Trademark S Constitution Assembly, 69 members of the Central Legislature plus 10 immigrant members equal 79. Consequences of setting up of the new dominions. His Majesty Unregistered Trademark S government lost all the responsibility to the new dominions. The suzerainty of His Majesty Unregistered Trademark S government over the Indian states lapsed. All the treaties or agreements in force at the passing of the Act lapsed. The title of a OE Emperor of India was dropped from the titles of British Crown. The office of Secretary of State for India was abolished in the provisions of GOI Act 1935 relating to the appointments to the civil service or civil posts under the Crown by the Secretary of the State ceased to operate. Civil servants, Section 10 provided for the continuance of service of the government servants appointed on or before August 15, 1947 under the governments of new dominions with full benefits. Armed Forces, Sections 11, 12, and 13 dealt with the future of Indian Armed Forces. A partition committee was formed on June 7, 1947, with 2 representatives from each side and the Viceroy in the chair, to decide about the division thereof. As soon as the process of partition was to start, it was to be replaced by a partition council with a similar structure. First and second schedules. First schedule listed the districts provisionally included in the new province of East Bengal, Chittagong Division, Chittagong, Nakholiantipura. Dhaka Division, Vikarganj, Dhaka, Faridpur, and Mimensing. Presidency Division, Jessa, Murshidabad and Nadia, Rajshahi Division, Bogra, Dinajar, Mulda, Rajshahi and Rangpur. Second schedule listed the districts provisionally included in the new province of West Punjab, Lahore Division, Gujranwala, Gurdaspur, Lahore, Sheikhupura and Sikut. Rawalpindi Division, Attock, Gujarat, Jhelum, Rawalpindi and Shahpur. Multan Division, Mira Ghazi Khan, Jhang, Nyalpa, Montgomery, Multan and Muzaffargarh. Princely States. On June 4, 1947, Mountbatten held a press conference in which he addressed the question of the princely states, of which there were then a total of 635. The treaty relations between Britain and the Indian states would come to an end, and on August 15, 1947, the suzerainty of the British Crown was to lapse. Consequently, the princely states would assume independent status. They would be free to choose to accede to one or the other of the new dominions. In the event, between August 1947 and March 1948, the rulers of several Muslim-majority states signed an instrument of accession to join Pakistan. These included Bahawalpur, Chitral, Dur, Kalat, Kherpa, Karen, Lasbela, Makran, and Swat. Official names, Section 1(I) of the Act provided as follows: as from the 15th day of August, 1947, 2 independent dominions shall be set up in India, to be known respectively as India and Pakistan. Aftermath. India. Lord Mountbatten of Burma, the last Viceroy, was asked by the Indian leaders to continue as the Governor-General of India. Jawaharlal Nehru became the Prime Minister of India and Sardar Vallabhbhai Patel became the Home Minister. Over 560 princely states acceded to India. The state of Jammu and Kashmir, which was expected to accede to Pakistan on account of his 77% Muslim majority and its cultural and commercial links to West Punjab, but whose Hindu ruler chose to accede to India, became a disputed territory. The states of Junagadh and Hyderabad, with majority Hindu populations but with Muslim rulers, were merged into India soon after Lord Mountbatten left India in 1948. Pakistan. Muhammad Ali Jinnah became the Governor-General of Pakistan, and Liaquat Ali Khan became the Prime Minister of Pakistan. 3 princely states geographically inalienable to Pakistan joined the Dominion. Partition. There was much violence, and many Muslims from what would become India fled to Pakistan. And Hindus and Sikhs from what would become Pakistan fled to India. Many people left behind all their possessions and property to avoid the violence and fled to their new country. See also, Pakistan Movement, Indian Independence Movement, Political Integration of India, Notes. References, Indian Independence Act 1947. Original statute from the UK Statute Law Database. Office of Public Sector Information, National Archives, UK. Retrieved April 30, 2010. Indian Independence Act 1947. Revised statute from the UK Statute Law Database. Office of Public Sector Information, National Archives, UK. Retrieved June 2, 2008. Parliament and India, 1858 Euro 1947. United Kingdom Parliament. Retrieved June 2, 2008a.
So this was a video for independence, Government of India Independence Act 9%. For your reference, I tried to include voice of that video. Video URL is available on text of this video. If you intend to see that, you can download that and watch yourself for your additional knowledge. I was talking about Independence Government of India Act 19, Government of India 1935, which ruled us between 1935 to 1947 and further to 1950. So you may say it was in full rule on us from 1935 to 47. This was about 35 to 47, 12 years. and then 3 years more until our legislation came into being, that is Constitution of India, super law of India, Bharat. So we were governed by this law, Government of India Act 1935, since 1935 to 1947, and then to 1915 in fact. And I just told you section 39, which is about English language, formal English language. Then I'll just give you a brief, I'm not going to speed it. There's a very long document. It's about, you can say, on this file, 341 pages, and this is not useful to talk of all, just for information, this, because you should know what happened before going to further expressions and further calculations of what you should in your life, as far as law is concerned, as far as constitution is concerned, and as far as the government is concerned, as far as institutions are concerned, and we are concerned. So section 40 of that is, no discussion shall take place in federal legislature with respect to conduct of any judge of federal court or a high court in discharge of his duties. In this subsection, reference to high court shall be construed as including a reference to any court in federated state which is a high court for any of purpose of part 9 of this act. If Governor General in his discretion certifies that discussion of a bill introduced or proposed to be introduced in federal legislature, or of any specified clause of a bill, or of any amendment moved or proposed to be moved to a bill, would affect discharge of his special responsibility for prevention of any grave menace to peace or tranquility of India or any part thereof, he may in his discretion direct that no proceedings or no further proceedings shall be taken in relation to bill, clause or amendment, and effect shall be given to direction. 41. Validity of any proceedings in federal legislature shall not be called in question on ground of any alleged irregularity of procedure. No officer or other member of legislature in whom powers are vested by or under this act for regulating procedure or conduct of business or for maintaining order in legislature shall be subject to jurisdiction of any court in respect of exercise by him of those powers. Chapter 4 in same, legislative powers of Governor General, section 42. If at any time when federal legislature is not in session, Governor General is satisfied that circumstances exist which render it necessary for him to take immediate action, he may promulgate such ordinances as circumstances appear to him to require, provided that Governor General shall exercise his individual judgment as respects the promulgation of any ordinance under this section if a bill containing same provisions would under this act have required his previous sanction to introduction thereof into legislature, and shall not without instructions from his majesty promulgate any such ordinance if he would have deemed it necessary to reserve a bill containing same provisions for significance of his majesty's pleasure thereon. An ordinance promulgated under this section shall have same force and effect as an act of federal legislature assented to by Governor General, but every such ordinance shall be laid before federal legislature and shall cease to operate at expiration of 6 weeks from reassembly of legislature, or if before expiration of that period resolutions disapproving it are passed by both chambers upon passing of second of those resolutions shall be subject to provisions of this Act relating to power of His Majesty to disallow acts as if it were an act of federal legislature assented to by Governor General, may be withdrawn at any time by Governor General, if and so far as an ordinance under this section makes any provision which federal legislature would not under this act be competent to enact, it shall be void. Then 43, power of governor. If at any time Governor General is satisfied that circumstances exist which render it necessary for him to take immediate action for purpose of enabling him satisfactorily to discharge his functions insofar as he is by or under this act required in exercise of thereof to act at his discretion or to exercise his individual judgment, he may promulgate such ordinances as in this opinion circumstances of case require. An ordinance promulgated under this section shall continue in operation for such period not exceeding 6 months as may be specified therein, but may by a subsequent ordinance be extended for a further period not exceeding 6 months. An ordinance promulgated under this section shall have same force and effect as an act of federal legislature assented to by Governor General, but every such ordinance shall be subject to provisions of this act relating to power of His Majesty to disallow acts as if it were an act of federal legislature assented to by Governor General, may be withdrawn at any time by Governor General if it's an ordinance extending a previous ordinance for a further period shall be communicated forthwith to Secretary of State and shall be laid by him before each House of Parliament. Even so far as an ordinance under this section makes any provision which federal legislature would not under this act be competent to enact, it shall be void. Functions of Governor General under this section shall be exercised by him in his discretion. 44. Power of Governor General in certain circumstances to enact acts. If at any time it appears to Governor General that for purpose of enabling him satisfactorily to discharge functions insofar as he is by under this act required in exercise thereof to act in his discretion or to exercise his individual judgment, it is essential that provision should be made by legalization. He may be by message to both chambers of legislature explain circumstances which, in his opinion, render legislation essential and either enact forthwith as a Governor General's Act a bill containing such provisions as he considered necessary, attach to his message a draft of bill which he considers necessary. When Governor General takes such action as is mentioned in paragraph above of preceding subsections, he may at any time after expiration of 1 month enact as a Governor General's Act bill proposed by him to chambers either in form of draft communicated to them or with such amendments as he deems necessary. But before so doing, he shall consider any address which may have been presented to him within said period by either chamber with reference to bill or to amendments suggested to be made therein. A Governor General Acts shall have same force and effect and shall be subject to disallowance in same manner as an act of federal legislature assented to by Governor General, and if and in so far as Governor General's Act makes any provision which Federal legislature would not, under this act, be competent to enact. It shall be void. Every Governor General's Act shall be communicated forthwith to Secretary of State and shall be laid by him before each House of Parliament. Functions of Governor General under this section shall be exercised by him in his discretion. Chapter 5. Provisions in case of failure on constitutional machinery. Power of Governor General to issue proclamations. Section 45. If at any time Governor General is satisfied that a situation has arisen in which government of federation cannot be carried out in accordance with provisions of this act, he may, by proclamation, declare that his function shall to such extent as may be specified in that proclamation be exercised by him in his discretion. Assume to himself all or any of powers vested in or exercisable by any federal body or authority, and any such proclamation may contain such incidental and consequential provisions as may appear to him to be necessary or desirable for giving effect to objects of the proclamation, including provisions for suspending in whole or part of operation of any provisions of this act relating to any federal body or authority. Provided that nothing in this subsection shall authorize Governor General to assume to himself any of powers vested in or exercisable by federal court, or to suspend either in whole or in part operation of any provision of this act relating to federal court. Any such proclamation may be revoked or varied by subsequent proclamation. A proclamation issued under this section shall be communicated forthwith to Secretary of State and shall be laid by him before each House of Parliament. Unless it is a proclamation revoking a previous proclamation, shall cease to operate at expiration of 6 months, provided that if and so often as a resolution approving continuance in force of such a proclamation is passed by both Houses of Parliament, rule of proclamation shall, unless revoked, continue to be in force for a further period of 12 months from the date on which under this subsection it would otherwise have ceased to operate. If at any time Government of Federation is for continuous period of 3 years been carried on under by virtue of proclamation issued under this section, at expiration of that period, proclamation shall cease to have effect and Government of Federation shall be carried on in accordance with other provisions of this Act, subject to any amendment thereof which Parliament may deem it necessary to make, but nothing in this subsection shall be construed as extending power of Parliament to make amendments in this Act without affecting accession of state. If Governor General by proclamation of this section assumes to himself any power of federal legislature to make laws, any law made by him in exercise of that power shall, subject to terms thereof, continue to have effect until 2 years have elapsed from date on which proclamation ceases to have effect, unless sooner repealed or re-enacted by act of appropriate legislature, and any reference in this act to federal acts, federal laws or acts or laws of the federal legislature shall be construed as including reference to such a law. Functions of Governor General under this section shall be exercised by him in his discretion. Then governors' provinces. Now these are going to provinces. The same thing will be repeated there. I'll just start something and then leave it behind because you can do yourself. This is 46. Subject to provisions of next the succeeding section with respect to Berar, following shall be governors' provinces, that is to say Madras, Bombay, Bengal, United Provinces, Punjab, Bihar, Central Provinces, Berar, Central Provinces and Berar, Assam in Northwest Frontier Province, Orissa, Sindh, and such other governors' provinces as may be created under this Act. Burma shall cease to be a part of India. Burma shall cease to be a part of India. This means it was a part of India. In this Act, expression province means unless context otherwise requires, a governor's province and provincial shall be construed accordingly. 47. Whereas certain territory in this Act referred to as Berar is under sovereignty of His Exalted Highness Nizam of Hyderabad, but is at date of passing of this Act. By virtue of certain agreements subsisting between His Majesty and His Exalted Highness, administered together with central provinces. So Berar is under sovereignty of His Exalted. So the Highness of Nizam of Hyderabad, Berar is there. And whereas it is in contemplation that an agreement shall be concluded between His Majesty and His Exalted Highness, whereby, notwithstanding continuance of sovereignty of His Exalted Highness over Berar, Central Province and Berar may be governed together as one governor's province under this Act by name of Central Province and Berar. Now, therefore, while any such agreement is in force, Berar and Central Provinces shall, notwithstanding continuance of sovereignty of His Exalted Highness, be deemed to be one governor's province by name of Central Province and Berar. Any reference in this Act or in any other Act to British India shall be construed as a reference to British India and Berar, and any reference in this Act to subject of His Majesty shall, except for purpose of any oath of allegiance, be deemed to include a reference to Berar, Berar is subject of His Exalted Highness. Any provision made under this Act with respect to qualifications of voters for provincial legislature of central provinces and Berar or voters for Council of States shall be such as to give effect to any provisions with respect to those matters contained in agreement. If no such agreement is concluded, or if such an agreement is concluded but subsequently ceases to have effect, references in this Act to central provinces and Berar shall be constituted as references to central provinces, and His Highness, His Majesty in Council, His Majesty in Council may make such consequential modifications in provisions of this Act relating to central princes as he thinks proper. Provincial executive, governor. Now I think it's going to state like this. 40, anyway, let us read something. 40. Governor of a province is appointed by His Majesty by a commission and the royal sign manual. Provisions of third schedule to this Act shall have effect with respect to salary and allowances of governor, and provision to be made for enabling him to discharge conveniently and with dignity duties of his office. Then 49. Executive authority of province shall be exercised on behalf of His Majesty by governor, either directly or through officers subordinate to him, but nothing in this section shall prevent the federal or provincial legislature from conferring functions upon subordinate authorities or be deemed to transfer to governor. May function any functions conferred by any existing Indian law on any court, judges, or officers or the local or other authority. Subject to provisions of this Act, executive authority of each province extends to matters with respect to which legislature of province has powers to make laws. Then administration of provincial affairs. So this is all in continuation, just 50 section and section 50. There shall be a council of ministers to aid and advise the governor in the exercise of his functions, except insofar as he is by or under this act required to exercise his functions or any of them in discretion, provided that nothing in this subsequent shall be considered as preventing governor from exercising his individual judgment in any case, whether by or under this act he is required to do so. Okay, we'll see further, which is I think it states the Governor General, again, if governor is coming 51, 52, same special responsibility of the governor. I leave this behind, and then there is another one. 53 is also provisions as to instrument of instructions. This is also same governor state level. Superintendent of Governor General. We'll all leave this. So I'm leaving this all governor's area because it's nothing really specific in that. Some repetitions of previous one and some sort. Provincial legislature, same thing. So it's just moving up and up in a way that we do not need time for this, and it's not necessary taking all this. Now, I'll go further down and then you say disqualification of membership. I don't think necessary to discuss all this. Part 3, and penalty for sitting and voting without qualification. All right. This is 70, section 70. If a person sits or votes as a member of a provincial legislature, assembly, or legislative council when he is not qualified and disqualified for membership thereof, when is prohibited from so doing by provisions of subsection 3 of last preceding section, he shall be liable in respect of each day on which sits and votes a penalty of 500 rupees to be recovered as a debt due to province. So, and release of members and others of members states level, so we leave it. And legislative procedure is the same as there. I just want to see where we can go for the same thing. Legislative procedures of the cross, financial matters, and whatever is. All the states have themselves. Legislative powers of governor can is a petition of state festivals for union, and go there. Excluded areas and partially excluded areas. Let us see what it says. Chapter 4, excluded areas and partially excluded areas, and section 91. This is in this act. Expression excluded area and partially excluded area means respectively such areas as His Majesty may be ordered by order in council can declare to be excluded areas or partially excluded areas. Secretary of State shall lay a draft of order which is supposed to recommend His Majesty to make under this subsection. Well, this means the same type of a junior level it is going to be. So, constitutional machinery. This is provisions in case of failure of constitutional machinery. Chief Commissioner provinces, and it's a legislative procedure for distinct powers, the same thing as it was there, it must be there as well. I think I will save time by limiting all this. Alright, Government of India Act 1935. So we are just moving for sake of moving. Restrictions to legislative power. Problem is this was some time. And hence, oh my god, why is not working? Yeah. Provisions with respect to discrimination. Let us see what it says. This is section 111. Subject to provisions of this chapter, British subject domiciled in United Kingdom shall be exempt from operation of so much of any federal or provincial law. Imposes any restriction on the right of entry into British India. What is this? Subject to provisions with respect to discrimination, subject to provisions of this sector, a British subject domiciled in United Kingdom shall be exempt from operation of so much of any federal or provincial law as imposes any restriction on right of entry into British India, imposes by reference to place of birth, race, descent, language, religion, domicile, residence, or duration of residence, any disability, liability, restrictions or condition in regard to travel, residence, acquisition, holding or disposal of property, holding of public office, or carrying on of any occupation, trade or business of profession. Provided that no person shall by virtue of this subsection be entitled to exemption from any such restriction, condition, liability or disability as aforesaid, if and so long as British subjects domiciled in British India are by or under law of United Kingdom, subject in United Kingdom to a like restriction, condition, liability, or disability imposed in regard to same subject matter by reference to same principle of distinction. For purpose of preceding subsection, a provision whether of law of British India or of law of United Kingdom empowering any public authority to impose quarantine regulations or to exclude or deport individuals wherever domiciled who appear to that authority to be undesirable persons shall not be deemed to be a restriction on right of entry. Notwithstanding anything in this section, if Governor General or, as case may be, Governor of any province by public notification certifies that for prevention of any inconvenience to peace or tranquility of any part of Bharat India, or as case may be of any part of province, or for purpose of combating crime of violence intended to overthrow government, it is expedient that operation of provisions of subsection of this section should be wholly or partially suspended in relation to any law, then while notification is in force, operation of those provisions shall be suspended accordingly. Anyway, Now, what is taxation? Taxation is there, and leave taxation behind. What is it? Companies incorporated in United Kingdom. What's the not political? This is it's not political. So we have to see where we can understand something. Companies incorporated in India, leave that behind as well. We're not interested in companies. And ships and aircrafts and subsidies for encouragement, leave the subsidies also. And supplemental power to secure reciprocal treatment by convention. I think this may be something. Let's read 118. If after establishment of federation, a convention is made between His Majesty's government in United Kingdom and federal government, whereby similarity of treatment is assured to United Kingdom British subjects domiciled in British India and to companies incorporated by or under laws of British India and in British India to British subjects domiciled in United Kingdom and to companies incorporated by or under law of United Kingdom. In respect of matters or any of matters with regard to which provision is made in preceding sections of this chapter, His Majesty may, if he is satisfied that all necessary legislation has been enacted both in United Kingdom and in India for a purpose of giving effect to convention, by order in council declare that purposes of those sections are to such extent as may be specified in order sufficiently fulfilled by the convention and legislation, and while other in force operation of those sections shall to that extent be suspended. An order in council under this section shall cease to have effect if and when the convention of which it relates expires or is terminated by either party thereto. Section 119, professional and technical education in general. This important one, I think. No bill or amendment which prescribes or empowers any authority to prescribe professional or technical qualifications which are to be requisite for any purpose in British India, on which imposes or empowers any authority to impose by reference to any professional or technical qualification, any disability, liability, restriction or condition in regard to practicing of any profession, carrying on any occupation, trade or business, or holding of any office in British India shall be introduced or removed in either chamber of federal legislature without previous sanction of Governor General in his discretion, or in a chamber of a provincial legislature without previous sanction of Governor in his discretion. Governor General or a Governor shall not give his sanction for purpose of proceeding subsection unless he is satisfied that proposed legislation is so framed as to secure that no person who immediately before coming into operation of any disability, liability, restrictions or conditions to be imposed by or under that legislation was lawfully practicing any profession, carrying on any occupation, trade or business, or holding any office in British India shall accept in so far as may be necessary in interest of public that are debarred from continuing to practice that profession, carry on that occupation, trade or business, or hold that office, or from doing anything in course of that profession, occupation, trade or business, or in discharge of duties of that office, which he could lawfully have done if that disability, liability, restrictions, or condition had not come into operation. All regulations made under provisions of federal and provincial law which prescribes professional or technical qualifications which are to be requisite for any purpose in British India or imposed by reference to any professional or technical qualification, any disability, liability, restrictions or condition in regard to practicing of any profession, for carrying on any occupation, trade or business, or holding of any office in British India shall not less than 4 months before they are expressed to come into operation be published in such manner as may be required by general or special directions of Governor General or as case may be Governor, and if within 2 months from the date of publication complaint is made to Governor General or as case may be by Governor General that the regulations or any of them will operate unfairly as against any class of persons affected thereby, Governor General or Governor, if he is of opinion that complaint is well founded, may at any time before regulations are expressed to come into operation by public notification disallow regulations or any of them. In this subsection, expression regulations includes rules, bylaws, orders, and ordinances. In discharge of his functions under this subsection, Governor General or a governor shall exercise his individual judgments. If Governor General exercising his individual judgment by public notification directs that provision of last proceedings of section shall apply in relation to any existing Indian law, those provisions shall apply in relation to that law accordingly, and functions which under those provisions are to be performed in relation to federal law by Governor General and in relation to provincial law by Governor shall in relation to that existing Indian law be performed according as many be directed by notification by the Governor General. Exercising his individual judgment by Governor exercising we performed according as may be directed by notification by Governor General exercising his individual judgment, by Governor exercising his individual judgment, or partly by one and partly by one, only one other of them. 120 medical qualifications, let us say what medical says. So long as conditions set out in subsection 3 of this section continues to be fulfilled, a British subject domiciled in United Kingdom or India who by virtue of a medical diploma granted to him in United Kingdom is or is entitled to be registered in the United Kingdom as a qualified medical practitioner shall not by a virtue under any existing Indian law or any law made of federal or any provincial legislature be excluded from practicing medicine, surgery, or midwifery in British India or in any part thereof, or from being registered as being registered as qualified so to do on any ground other than ground on any ground other than ground that diploma held by him does not furnish a sufficient guarantee of his possession of requisite knowledge and skill for practice of medicine, surgery, and midwifery, and he shall not be so excluded on that ground. and he shall not be so excluded on that ground unless a law of federation or province, as case may be, makes provisions for securing that no proposal for excluding holders of any particular diploma from practice or registration shall become operative until expiration of 12 months after notice thereof has been given to Governor General and the university or other body granting that diploma, and that such a proposal shall not become operative or as case may be shall cease to operate if Privy Council on an application made to them under next succeeding subsection determine that diploma in question ought to be recognized as furnishing such a sufficient guarantee as aforesaid. If any university or other body in the United Kingdom which grants a medical diploma or any British subject who holds such a diploma is aggrieved by by proposal to exclude the holders of that diploma from practice or registration in British India, that body or person may make an application to Privy Council, and Privy Council, after giving a to such authorities and persons both in British India and in the United Kingdom as they think fit an opportunity of tendering evidence or submitting it is and submitting representations in writing shall determine whether diploma in question does or does not furnish a sufficient guarantee of, of possession of requisite knowledge and skill for practice of medicine, surgery, and midwifery, and shall notify their determination to Governor General, who shall communicate it to such authorities and cause it to be furnished or published in same manner as he thinks fit. Then condition referred to in subsection of this section is that British subjects domiciled in India who holds a medical diploma granted after examination in British India shall not be excluded from practicing medicine, surgery, or midwifery in the United Kingdom or from being registered therein as qualified medical practitioners except on the ground that their diploma does not furnish a except furnish which is on ground that the law does not furnish a sufficient guarantee of possession of requisite knowledge and skill for practice of medicine, surgery, and midwifery, and shall only be excluded on that ground so long as law of in the United Kingdom makes makes a provision for enabling any question as to of sufficiency of that diploma to be referred to and decided by Privy Council. Then a medical practitioner is entitled to practice or to be registered British India by virtue of a diploma granted in the United Kingdom or in the United Kingdom by virtue of a diploma granted in British India shall not be in practice of this provision be subjected to any liability, disability, practice restrictions, and by virtue of right. Well, now these are provisions regarding medical. We have just explained to you what is this. Following provisions of this section shall subject to modifications hereinafter mentioned apply in relation to British subjects domiciled in Burma who by virtue of medical diplomas granted to them in Burma or United Kingdom are entitled to be registered in the United Kingdom as qualified medical practitioners as they apply in return to British subjects domiciled in the United Kingdom who by virtue of medical diplomas granted in United Kingdom All right. Following provisional sections of the modification of references applying this. Okay. All right, that's done. Said modification as follows. So it shall not apply in any subsection limit. Now we'll move now to officers of Indian Medical Service. Per section 21, a person who holds a commission from His Majesty as a medical officer in Indian Medical Service or any other branch of His Majesty's forces and is on active list shall be virtue of that commission be deemed to be qualified to practice medicine, surgery and midwifery in British India and be entitled to register in British India or any part thereof as qualified. Now, Part 6, administrative relations between federation, provinces and states. So I think the same relation we have constitution. Just 122 says, executive authority of every province and federated state shall be so exercised as to secure respect for laws of federal legislature which apply in that province or state. So this is, I think, same. I leave it behind. And see, Governor General may require governor to discharge certain functions, and then 24 is 134 Federation to confer powers on all this move like this. 125 is administration of federal acts in Indian state. All this I'm saying as is a very, very long document. We'll keep it from time to time. Now it's about 100 pages I've reached, and control of federation over province in certain cases, acquisition of land. So well, I want to say is what I want to say is that some big problem in this one. Yeah. Purpose of mine regarding reference to this Government of India Act 1935 is different. Means what I discovered from this, that our constitution in 1949 withdrew about many provisions from Government of India Act 1935. You may say about 66% or two-third sections or provisions included within that act we just are discussing with have been inserted into draft of Constitution of India in 1949. This is one part. Other part is about one-third of inclusions were imported from other 12 constitutions of various countries, including Australia, Canada, and many others. So 66%, two-thirds from Government of India Act 1935, and one-third part from 12 other nations. This means there might be very detailed, elaborated work conducted by those people, those authors of constitutions committee led by Dr. Ambedkar and many others. In those days, they might have worked a lot day and night. No computers were there. Maybe typewriting they did themselves, or many drafts they typed something, they then edited that, checked one, then removed that, put another typing, because those typing, those were not auditable. So Constitution took, I think, many years for its complete structure, and so many people were involved, intelligent, highly intelligent, brilliant people, and they produced that document for us based on this hard work. This is for us, Constitution of Bharat, India is for us, and I will discuss this act of Government of India Independence 1947 further later, along with two Government of India Act 1935 and Government of India and Independence Act 1947. Both are linked because we were impacted upon by Government of India Act for 3 years from 1947 to 50. Of course, this act was applicable to us, and also provisions of Government provisions of India Independence Act 1947. Both were crumbled, or you can say imposed on us, and then birth was given, generation was given to Constitution of India, you can say a statutory law in 1950, which still moves on us, still controls us, and that is great deal because it includes Government of India Act 1935 as well as Independence of India Act 1947, and further amendments on that, 395 articles in Constitution of India insert, and top article, top mandate, top rule, preambles, which is now structural management, structural requirement, an objective of this constitution and for public benefit, public rights and privileges. In fact, to be very clear, preamble is not preamble alone. It takes everybody to a destination of this country, what sort of country we are, what sort of society we are, what we should be. Don't think it only for legal angle, think it from a common sense angle, which everybody has. Constitution of Bharat India is not a document that needs scientific knowledge or that needs medical or engineering knowledge. It needs simple common sense knowledge, which way we want to live in this country. This is actually a practical way of life in all sectors of society: justice, liberty, and opportunity. Justice, liberty, and opportunity. Everybody wants to live free of restrictions. Of course, the limited restrictions, major restrictions are there, but you have various rights, fundamental rights, defined rights, directed rights, and your own approach of personal level rights, natural rights, you can say. It has given us various privileges in forms of rights, in forms of fundamental values, in form of fundamental rights such as rights to education, rights to freedom of speech, rights to performance and you can say profession of your faith or religion, and various other rights like you have to enjoy nature. You can enjoy nature without any cost. You can go to the river, you can go to tree, you can go to mountain without any taxation. You are free to enjoy that. You have to enjoy sun, air, water, etc. This, of course, Constitution has not brought it to us. It was natural, but it has mandated that we shall not stop you if you want to enjoy these, if you want to have these rights and privileges for your life, or if you have to do fundamental duties are also mentioned in Constitution, which is actually a minimum one, and those who understand them, they can do something for this country. Purpose is explanation of what's happening. That is major purpose. Acts are available. You can download yourself. You can read it. I'm just for advice. It takes time to explain, to read, to understand. And I know people are not going to waste time in these acts because all are busy. They think so. It's not a question of you're busy or you're not busy. It's a question of to learn. If you don't know who we are, who I am, from where I came, what's my rights, I cannot protect myself as well as I cannot protect others. Lead, everybody has to take. What level lead you take, that's up to you. You may take lead to your job only or to your staff only, that's one part. And if you have to lead whole society, that's another part. Or if you want to lead nation, that's another part. For every field in law, in luminaries, you can say we have to learn. And that is a question mark. You have to learn. But you have to learn only when you see what's happening around you. If you keep your eyes closed, if you don't want to see what's happening, if you leave to someone, oh, I need not bother about this, let this happen and somebody else to take care of that. Yes, you are right. Somebody has to take care of that. and other somebody would say, let somebody has to take care of that. Then we have to find where is that somebody. Everybody is passing responsibility from one shoulder to other shoulders. Who is responsible? This means no one is responsible. First, we have to innovate who is responsible, and this innovation shall never finish because no one is responsible. Unfortunately, our society is of that standard. All are responsible, but no one is responsible. All are leaders, but no one is leaders. All are sovereign, but no one is sovereign. All are socialist, but no one is socialist. And all are secularist, but no one is secularist. All are democratic, but no one is democratic. All are republics, no one is republic. This means preamble is only for record and articles in constitution only for record. Those only few people who have vested interest, they know and understand that. But we who are large public, 99% people who are at large, who are actually have suffered also to some extent or someone, have been working very fast. This doesn't give a relief to me. My question is, I cannot leave something to one else. It is a question that my right is involved with. If my right is affected, my present is affected, my future is affected by some leader who has vested interest, should I allow that leader to impact upon me? I cannot expect that. I cannot accept that. I cannot accept that. Leader is not my God. I leave it to God, I can say. But why should I say God? When God has made me fully strong to think, to work, to act upon, why should I leave everything to fortune or misfortune? No. I am a human being. I am a body. I am a soul. I am a machine. I have everything in me. I have mind, I have courage, I have energy, I am initiated, I am proactive. When I say I, it doesn't mean I in person. First thing that I means nation, I means Bharat, I means Bharat public. You may say we or I, it doesn't make difference for me. Ultimately, it's only verb. It's only word. I means public. Public has to be strong, not a public which withdraw from responsibility, which withdraw from duties. No, we cannot withdraw from duties when we expect nation to give us something and we give to nation. We have to give to nation its power. We cannot leave this nation in hands of certain people who are called politicians. We cannot leave this nation to move on these merciful, dutiful, dirty community of political leaders. They have no mercy, they have no sentiments, they have mercy and sentiments for certain groups only who are their own groups, not for whole nation. A leader means leader should be leader for whole nation, irrespective of what group voted him to power or did not vote to power. This constitution itself is fake in you can say nation as a register power. Very strong we should be. After all, this nation belongs to us, each and every citizen of this country. This nation is not property of some politicians. This nation is not property of certain associations. This nation is property of public and all sections of public, irrespective of strength or money. Public cannot be taken for granted. and even whose sons I have seen every day as moving out with their parents, enjoying life. They are not concerned even with education. I was surprised. Not concerned. We are not concerned about anything. We are only concerned about ourselves. We have seen 72 years how we moved, and now we are seeing something. There have been many changes in government, many changes in presidency and PMship. People have come and gone. All spoke something, all proposed something. We would do this for you and we would not do this for you. We will cost to you this and we will not cost to you this. All delivered certain dreams. They delivered dreams and they sold dreams to people. And people bought their dreams, paid them value in terms of votes, and they continue to be governments for 70 years. 14 governments we have seen, 14 or 13 the governments we have seen. But question is, what improvement is coming in? There has been improvement indeed. Nevertheless, it's not adequate. We have to ensure that it multiplies, it thrives, and benefits society. But question is, we ask a question ourselves: is it happening, or it is all just keeping public in delusion of horizon? Are we in delusion of horizon? This question we have to ask ourselves. We know our political leaders cannot answer this. They cannot directly answer anything. It is beauty of our politics. Our politicians, who should work scientifically, who should work in an organized manner, you ask any question, they will never answer directly. Either also no comments, or thank you, or if they answer in a way taking many circles around and reaching to some irrelevant answer. This is general practice. This practice is very dangerous because your honors are public and you do not want to respond to them. It also means I am honor of this public. I am honor of public and I employed these politicians for my work to govern me, to represent me, and these politicians have failed to represent me, to govern me, then I have to reconsider my previous decisions. I have to re-establish what wrong I have done. I have to check it out. I have to check, like Krishna said, Praritranaya sadhunam vinashaya cha duskritam transanstapnarthaya sambhavami yuge yuge. Said that yuge yuge. Those who are not right, those who are wrong, those who are sinners, I'll damage, I'll destroy them. And those who are good, those who are right, I shall award them. And those institutions who have spoiled all this, I will set them right. That was a question. There's an answer from life. It is easy to blame others. Politicians' job is to work for people, to chart out plans for society, to find budgets, to get approvals from parliament, and to implement those items. But they are not working accordingly. They are just passing time. They are just saying they are happy that they are either MP or MLAs. They are happy in that. I don't know for what they are happy. Either they are earning a lot out of that illegally or they don't know how to work. They are not doing any factory, any work. They are not doing any industrial spare part work. They are not working on lathe machine. They do not work in sun. They do not work in field. They work only in a manner which is called ordinary desk work or speak work. They don't have any general knowledge depth, most of them. Now people are coming as educated also, but those people who have been deprived of education for centuries, or deprived of food for centuries, those people must be cared for, and those people only on whom public banks upon. Bank upon because we have complete, you can say, we have complete management of our country into our hands, but we don't understand that this is our management. Constitution is ours, but we don't consider this ours. We are writer of Constitution, we are author of Constitution, we are empowerer of Constitution, we are approver of Constitution, we are giver of Constitution to ourselves, but we do not understand this. We do not understand this. As general public, as common man, we don't understand. That is the problem. Why don't we have confidence into ourselves? Why we are just hell-bent to make money, live and eat? If you ask someone, I have to do nothing, I have to live, I have to earn, I have to then what I have to do with Prime Minister, what I have to do with Minister and all that. Yes, they will take care of this nation. Yes, they shall take care of this nation. If you take care of this nation, you have told them in silence, oh, you take care of for us. We are just working for our survival. So they are also working for their survival. Maybe Prime Minister, maybe President, maybe MPs. No one is working for society. They are working in a way that their votes are kept intact. There is no other destiny. There is no other aim to these people. If they feel that by this act my votes are safe, my party is safe, my position is safe, I accept this, let a position speak and go to hell. Let the public go to hell if this part of public is happy with my performance or my proposal, and this part of public is happy, and this part of public is happy, this part, and this part vote me, I stay safe in my position. That is thinking developed in 72 years, which is very dangerous. Very dangerous. Our constitution mandates, preamble mandates equal treatment for all, equal opportunity for all, equal justice for all. This is what is maintained. But we never analyze it. We think some advocate would tell us, some judge will tell us. Why shall advocate would tell you? Why should a judge tell you? Is judge God? Is advocate God? Or is the PM God? You are destiny maker of your own. Bharat Bhagya Vidhata. Janagan Man Adhinayaka Jayohe Bharat Bhagya Vidhata. What does this line of national anthem tell you? Have you ever analyzed? If you have not analyzed, whose fault is that? This is not French language. This is not anti-log or log. This is not allogath. This is not physical chemistry or chemical physical biology or atomic physics. This is simple line in your own language. Janaganaman Adhinayaka Jagati Bharat. Who is Jan, who is Gan, who is Man, who is Bharat, who is Bhagya, who is Data? You don't know this. You have to write your luck. You have to use this legislative body and government to use and write your luck, and you have to force them. Can you force them? You are not forcing them. They are forcing you. They are forcing you. They are bringing such drafts, such bills that impact your life. Only they think for certain section, either to tease that section or to help that section, torture them or to develop them. This is what is happening. This is what's happening. And we have been, you can say, divided into many, we have been distributed ourselves into many sections, depending on state, depending on language, depending on religion, depending on something rich and poor. And we have been abused by government, by legislative body, by someone by money power, and we have somebody are plus and somebody are minus. Somebody cares for one who is benefited doesn't speak for those who are lost. Do you need that type of Bharat? Does preamble speak for that? I don't know. Do you know? Silence you are maintaining. You have been maintaining silence. For what? Why are you not so broad-minded and encouraged to speak for others? You are ready to speak for some other country. You are ready to speak for someone else. You are ready to speak for yourself. You say you belong to Bharat, which is Dharma. Right? Dharma means you have to speak for all. What Vasudev Kutam? When you are saying Vasudev Kutam, but you are not speaking for all world, and not even for your country you are speaking. Unfortunately. This is the problem in this country. And these political people know it very well that we are a stupid, sleeping society which has no courage to speak against this. Therefore, one man is ruling this country and we are submitting to this one man. 140 crore people are sitting as if they are stones, and stones cannot speak. That is a problem. We are a stone country. We are a dead country. We are a fossil country. We cannot speak for us, for our brothers, for our sisters, for our neighbors, for our society. We cannot speak us, and we fight for politicians. Unfortunately, we fight for BJP, we fight for Congress, we fight for Modi, we fight for those rascals who are looting us. We don't fight for our neighbors, for our society, unfortunately. We talk as if these are honors, Modi Bhakt, Congress, this and that. We are wasting time in those stupid activities. We are not caring about our country. What is right, what is wrong. Even if PM says right or wrong, we accept that. We never analyze that. And PM knows it very well. He knows very well. And he knows also that people believes him, and that is a drawback. We should not believe any leader, whoever one be, because leaders are leaders only. They are not saviors. We need saviors. Okay, vote is one thing. Don't worry about vote. You voted to whoever, fine. But don't stop at vote. Vote is your right. But whatever leader says or does, it's not your right or under force. You are to accept that. You see what he has done and think on that. Forget vote and forget which party you support. You have only one party, and that's public of this country. Support that public. Don't think of religion, don't think of caste, think of future. Religion is not giving you food. No religion is giving you food. You work hard and get food. Only those people who have too much money, they don't care for anything. But you have given them money. These people are looting your money and giving them. So you are accepting that also. What I am saying is, first be responsible citizens. First be responsible citizens, because those who have too much money, they did not get this money by excavation wages. They looted banks. They looted our taxes. They abused political parties, donated them and made money. That money is not money of hard work. That money is of soft and hard loot of this nation. So don't respect any political leaders because they don't deserve your respect. They are respectless. They should be respectless. They should be under your check all time, whoever they may be. Don't be swayed by their stupid, fake statements, whoever delivers that statement. Think of all citizens of this country. Don't think leaders of this country. Think of professional leaders, professions, but not politics. These people were neither for independence. They want to just keep your hands so that you don't move this and that and you accept them all time, just like British used to do and others used to do. They can never be your friend, your brothers, sisters. In a speech, they would say, Bhaiyo, Bhano, brothers and sisters, but they are neither brothers nor sisters to you. They are your spoilers. And when you hammer them, they will be set right, not otherwise. You have to keep a watch at democratic level. Vote is not democracy alone. Vote is a part of democracy. You have to hit them all time and raise questions. Answer me this, answer me this, and answer me this. And I have to answer to public, and if he answers fine, he walks away you wish, that's fine, or else Jai Bharat, Vande Matram. That's it. No more on that. I'll talk to you later on. Thank you very much.